Dennis Dicki here?
Yes, ma'am.
State of Michigan versus Dennis Dicki, 26-01116. Council, may I have your appearance, please?
Thank you, Your Honor. May it please the court, Assistant Prosecuting Attorney Dan Smith, appearing on behalf of the people of the state of Michigan.
Mr. Dennis Dicki.
Yes, ma'am.
Okay, you're here for a probable cause conference on an assault with intent to do great bodily harm, less than murder, or by strangulation. And then there are two misdemeanor counts, one of domestic violence, one an assault and battery. It appears that you applied for public defense representation, but you were denied.
Yes, ma'am.
So you have a couple of options as it relates there. You can appeal the denial if you believe that you failed to provide all of the financial information that they needed to make a accurate decision about your financial status, or you can hire your own attorney, or you can waive counsel and represent yourself, which is not advised. How would you like to proceed?
I would like to reapply.
You want to appeal the denial?
Yes, ma'am.
Okay. I'll find out how. I think you just contact their office to do an appeal, but I'll ask one of the public defenders here to get you better information in just a moment. It looks like I have here. I already addressed this. This is the one that went out of town.
Yeah.
Okay, you work as a truck driver, correct?
Yes, ma'am. Yes, ma'am.
Okay, I think I've already addressed your bond that you are on tether.
Yes, ma'am.
Okay, so I've addressed it so that you are allowed to travel outside of this state for work purposes. You just need to notify us in advance where you're going so that it won't trigger a violation, okay?
And is it any way possible that I could get the tether off? Because even with this case that's going, Anitra, my wife, she called down there to get the tether. I was in the county. She called down there to have me have it.
She called down there to have you have what?
The tether.
Okay.
And we're supposed to have a no contact. She was getting me out. So is there any way that I could,
She was getting you out of what?
when I was in the county? Yes, ma'am, I'm sorry. I was in county.
You were in lockup, yeah.
Lockup, yes, ma'am. And we're not supposed to have a contact. And she called to have me, because I couldn't get out until I had this tether.
Okay.
So if I could just, get the case dismissed because it's not true. I can
Yeah,
prove
well,
it now, but-
it would be lovely if cases can just be dismissed because it's not true, right?
Right.
But we don't know. What we
Right.
have is your word versus her word at this point.
Right.
And so that creates a question of fact. And so we have to move forward. And if it goes all the way to the jury, then the jury decide
Right.
which one is the most credible side. But we didn't even get to that stage yet.
Okay.
We have to have a probable cause conference, which is today, which is scheduled for today. But you don't have an attorney, so I'm gonna give you an opportunity to appeal the denial. And then I'm assuming the alleged victim is, or at least one of them is your wife.
Yeah, and Hannah, the stepdaughter.
Okay. Okay, so we will give you an opportunity to appeal that. We'll treat next week as another probable cause conference.
Okay.
Council, was there an offer that you wanted to disclose at this time, or were you just gonna continue to PCC?
I will continue to PCC, Your Honor.
And did you want to address his motion to remove this tether?
We defer to the court.
don't think I have any, I don't have his criminal history. Do you have any prior convictions? Are you able to see that, counsel?
Yeah.
You didn't give me a pre-trial release.
Yes, the defendant has no prior criminal history on the CCA.
Okay, thank you. I'll grant your request to have the tether removed. You have to go back down to county so they can remove it. There's no contact order, will continue though. And we'll see you next week for another probable cause conference. Let's see. How does he appeal? Okay, you just call the office to counsel.
Yes, Your Honor. I happened to look up Mr. Dickey's file while I was here. It appeared he called and spoke to someone regarding the denial, I think, on April 28th,
Okay,
and provided some either new or additional information that was reevaluated and was determined that he was still not eligible. So he is certainly welcome to contact our office and apply or reapply, but unless there's been some change in his financial circumstances, see if he would qualify.
I applied today. I reapplied.
you reapplied today. Okay, so it's likely, just given your employment, that you may just make too much money for public defense. The threshold is not very high. Okay, and so we will navigate that after we figure out what happens if you just reapply today, what will happen. Okay, do you have any other questions at this time?
No, ma'am, but you did say I could get the.
You can have the tether removed,
Thank you.
and then because we're gonna treat next week as another probable cause conference, you do not need to appear in person, okay? You can appear via Zoom.
Do I have the date? This is it.
That's your next week's date. That's correct. Any additional matters for the record?
None
counsel?
from the people, Your Honor.
You're all set, sir.
Thank you.
Thank you. State of Michigan versus Damon Hemphill, 25-03845. Council appearance.
Thank you, Your Honor. May it please the court, Assistant Prosecutor Attorney Dan Smith, appearing on behalf of the people.
Edward Christensen on behalf of Mr. Hemphill, Your Honor.
Where's Mr. Hemphill?
I'm here.
Okay, thank you. Today was the date scheduled for probable cause conference. This is for carrying concealed weapon, and then there was a controlled substance analog and a weapons felony firearm. What I'm assuming this is. Let's see. Yes. This matter is scheduled for exam on the 15th at 8:30. Are we continuing to exam?
No, Your Honor. Actually, when he was arraigned, I told Magistrate Milmore that I'm going to be out of the country from the 12th through the 28th.
Okay, so your client wishes to waive his 21 days.
Yes, Your Honor.
Mr. Hemphill,
Yes, ma'am.
you have the right to have a preliminary examination within 21 days of the date that you were arraigned. Your attorney is going to be traveling on the 15th, which is the date that you are scheduled to have your exam. Are you willing to waive the 21-day timeline so this can be reset?
Yes, ma'am.
June 18th at 8:30. June 18th at 8:30 is your new date. Any additional matters for today's record?
Nothing from the people, Your Honor.
And none from the defense, Your Honor.
We're all set. We'll see you on June 18th in person at the court.
Thank
Your
you.
Honor.
You're welcome. Okay, this is State of Michigan versus Paula Thornton, 25-03601 and 26-01138. Appearance, please.
Thank you, Your Honor. May it please the court. Assistant Prosecutor Attorney Dan Smith appearing on behalf of the people.
Erin Robinson, Assistant Public Defender for Ms. Thornton. I have not had contact with her, Judge.
Oh. I will issue a call. Thank you. State of Michigan versus Atheme Johnson, 26-00336 and 26-0291.
Thank you, Your Honor. May it please the court. Assistant Prosecutor Attorney Dan Smith appearing on behalf of the people.
Jacob Riley on behalf of Mr. Johnson, who's present tonight.
Assistant Public Defender Mr. Strong, also on behalf of Mr. Johnson, who's staying to my left.
The charge was scheduled for sentencing today. I do have a pre-sentence report that was prepared on the 1st. Did the attorneys get a copy of that?
Yes, we did, Your Honor.
Yes, Your Honor.
Any reason to make corrections, updates, or deletions?
Nothing from the people, Your Honor.
We have none, Your Honor.
Didn't make allocution.
Your Honor, I think certainly Mr. Johnson has learned a lot through this process. He made a very bad decision in the moment. I think he was under some stress, under some fear, if he did the exact wrong thing. He knows now that he could have done a lot worse for him. Police is not something that we take lightly. He understands that certainly. He was very happy to resolve this to a misdemeanor plea and not have the felony on his record. I do think the recommendations and assessments of the report are fair and appropriate, and my request would be that the board adopt those recommendations, Your Honor.
Yes, Your Honor, in a similar fashion, I would also point out that Mr. Johnson has been readily forthcoming with his accountability in his misdemeanor case. He also acknowledges that his actions were not appropriate, time and place, as well as the actual substantive actions themselves. He is apologetic. I do believe he wishes to speak to them. Thank you.
I just wanted to say I appreciate you for taking the time dealing with this with me. I shouldn't have to be in this situation, but I put myself into it. I take accountability, full accountability, and I appreciate you.
Thank you. I appreciate you taking the time to consider your actions, because it's going to take your reflection and consideration for you to change this track. You didn't have any prior criminal activity prior to this, and then out of nowhere, back to back, you now have 2 convictions. And so even the way you presented yourself when you finally presented yourself to probation, they found you to be remorseful, respectful, forthcoming. That shows the court and your attorneys, there's some qualities there that are really more probably accurate as it reflects your character. And that these incidences are likely isolated, and that you won't be back here, given an opportunity to serve a term of probation. And it says here that you are eligible for HYTA status. So I will grant that. I will place you on a term of probation. I don't see any concerns about substance abuse or use. I see, the primary concern is for you to maintain your employment, and you are currently employed.
Yes, ma'am.
Where is that?
CBI rehabilitation.
So I'm going to let you maintain your employment while on probation. You're not to engage in any assaultive or threatening behavior. You're not to purchase, possess firearm, ammunition, or weapon of any kind. You're not to use alcohol, marijuana, or controlled substance unless you have a valid prescription. However, at this time, I'm not going to order testing because it was not related to the incident or a concern indicated in the report. You're not to be at any bars or nightclubs while on probation. Yeah, we don't know the victim for this, so I typically in a assaultive or jostling, I would continue the no contact, but can't do that because we don't have a victim. So again, no assaultive action of any kind. Of course, that doesn't include self-defense, but you're not to be an aggressor. You understand that?
Yes, ma'am.
Is a $30 per month oversight fee that will be assessed on file number 26-00336. I am going to order probation on both files, but they're going to run in tandem. So you're not doing two probations. They're going to be tracked at the same time. There's a $30 per month oversight fee for 6 months of probation, which is being ordered. And so you will pay $180 for probation oversight fees. $75 crime victim rights fee will be assessed on each file, plus $50 of state minimum costs will be assessed on each file. Going to waive discretionary fines and costs on each file. So file number ending in 291, you will owe a total of $125. Or $305 on the other file. You'll make monthly payments on that, okay? Do you have any questions at this time?
No, ma'am, I appreciate you.
I'm gonna give you a bice of rights as to probation. It tells you that you have the right to request early discharge from probation once you've completed half the original term ordered by the court. You can just hand that to me, thank you. Once you've completed half the original term ordered by the court, the instructions are there. You can use the court's MC 512 form, which is on the court website. And you would complete that form, file a copy of it with the probation department and serve a copy of it on the prosecutor's office. The prosecutor will have 14 days to respond in writing with any objections to your request for early discharge. If I set it for hearing to address your request, which I've never done at this point, I've just reviewed them off the record. But if for some reason I need to set it for a hearing, you do have the right to an attorney to represent you, but you wouldn't have the right to a court-appointed attorney to do that, okay? Do you have any questions at this time?
No, ma'am.
Okay. And I've not ordered you to do any programming. I just ordered you to maintain your job, so. Your probation officer also has the ability to make that request on your behalf for early discharge if there's no issues. Do you have any questions at this time?
No, ma'am, I appreciate it.
We'll get you, thank you. We'll get you downstairs to check in with probation before you leave, and then you're free to go. Best wishes to you. I hope that my path crosses your path again, it will be on positive terms. Thank you.
Thank you for the court time.
Thank you. State of Michigan versus, is it Isidoro Perez, 22-00617, 26-01130, 22-00839. Appearances, please.
Thank you, Your Honor. May it please the court, Assistant Prosecuting Attorney Dan Smith appearing on behalf of the people.
And thank you, Your Honor, and good morning. Jared Austin appearing on behalf of Mr. Perez. He appears with us remotely from the Ingham County Jail.
Okay, I think it's a little difficult to see him, but Mr. Perez, can you hear us? I don't know what's going on. Okay, great. Okay, this was a matter scheduled for probable cause conference on multiple files. And my understanding is that all these files are going to be waived to circuit court.
That is correct, Your Honor. My understanding is both parties would be waiving the respective rights of the preliminary hearing, having the matters bound over as charged. There is a pending global offer to be placed on the record.
Counsel?
Yes, Your Honor, that is my understanding. We have extended an offer to the defendant. I believe he's going to accept that offer in a circuit court. That offer was to plead guilty as charged to the 00617, plead to one count of carry of concealed weapon and person in possession of a weapon under the 26-01130, and we will be dismissing the 22-00839.
That's complete and accurate counting.
That is my understanding as well, Your Honor, and that is what I have conveyed to Mr. Perez. And just to simplify, it's just 2 felony counts on his new case, a misdemeanor count on one of his old case. His other 22 file that's not being pled on would be dismissed in its entirety, and any charge not being pled to and those other 2 cases would be dismissed.
Sounds good. Okay, Mr. Perez, you heard your offer, correct? Mr. Perez,
Can you hear me?
did you hear the offer that was placed on the record?
Yes, ma'am, I heard it.
Okay, you have the right to have a preliminary examination in each one of these felony files. Do you understand that?
Yes, ma'am, I do.
Okay, you also have the right at the time of the examination to have the prosecutor establish that they have sufficient probable cause that a felony was committed in each file and probable cause to charge you as the person who committed the felonies. Do you wish to unconditionally waive your examination in each of these files today?
Yes, ma'am.
Anyone promising you anything to get you to waive your examination?
No.
Any threats extended to you to get you to want to waive your examination? Excuse me?
No.
Okay, thank you. Okay, your bind over date is May 20th. That's the date the circuit court will receive the file from the district court, not a court appearance date for you, okay?
I think this microphone is not the best. I heard you though. I heard you. Okay.
Thank you. Give me just a moment.
Approach.
Yes, thank you. Bond. The bond a minute. Bond and file number 22-00839 is 510%. Bond and file number 617. Actually, no, I think those are old bonds. He needs new bonds. He was remanded on these for failure to appear. He does have a cash surety bond on 26-01130, 3,000 cash surety that will continue. There. Want to address bond on the other two files?
Not at this time, Your Honor. I think Mr. Perez realized it's likely to be in custody until we get his matter resolved in circuit court, so I would just ask that the bonds as they currently are remain as is.
Okay, you're all set, sir. Bonds will continue.
Hello. Sorry,
Thank you. Something's wrong with that.
microphone is not working.
Yeah, something's wrong with the microphone. The camera's not working either, actually.
I can hear you just fine. I can see fine too, so.
Thank you. You're all set, though. You can let the deputy know that.
Wonderful day.
I just didn't mean it's talking about the balance is $5. State of Michigan versus James Nicholovich, 25-03665, appearance, please.
Thank you, Your Honor. May it please the court. Assistant Prosecutor Attorney Dan Smith appearing on behalf of the people.
And thank you, Your Honor. Good morning. Jared Austin appearing on behalf of Mr. Nicholovich. He is appearing with us remotely from the Ingham County Jail.
Okay, this is a probable cause conference on controlled substance delivery and to substance delivery manufacturing less than 50 grams. The exam is scheduled for next week on the 15th at 9:30. Are we continuing to exam?
That would be our request, Your Honor. Yes.
Was there an offer?
Yes, Your Honor. I believe we have made an offer to dismiss count one.
So we'll see Mr. Nicholovich next week in person at the court. Do you have any questions today, sir?
No, I don't.
Okay, bond was set at 3,000, 10%. That will continue. Any additional matters for the record?
Nothing from the people, Your Honor.
Nothing at this time, Your Honor. Thank you.
Thank you. State of Michigan versus Daryl Morris, 25-03133. I saw Mr. Athens, but did we lose him? Maybe he's not here anymore. Let's see. Mr. Raleigh, did I just see him? I think he just stepped out to find Mr.
We're gonna be waiving, or we're gonna be transferring this to
Okay. What's happening? I think Mr. Etheridge is waiting. He's a what? He's on his way. Oh, Etheridge is doing that? Yeah. Who's this? We don't, what happened to Raleigh?
He's in the hallway doing the ground judge.
Yes, please. Because Andrew Timco is here. I thought I see Mr. Blackman, but I don't see him. He's on. Oh. Yeah, he could be a, we're done with Mr. Nicholovich. We have Jawan Edwards, we just don't have Blackman. We have Timco. State of Michigan versus Andrew Timco, 26-01137. Council, may I have your appearance, please?
Thank you, Your Honor. May it please the court, Assistant Prosecuting Attorney Dan Smith appearing on behalf of people.
Jacob Riley on behalf of Mr. Timco, who is not present, Your Honor. I have not had contact with Mr. Timco.
He's on Zoom.
So-
Yeah, he just needs to start his video. Mr. Timco, can you hear us?
Yes, ma'am.
What's your phone number?
My phone number, 517-977-3560.
Got the number you have, Mr. Raleigh?
Check. And 773-560, that is the number I have, yes.
Okay, you left a voicemail.
I did.
Did you get a call from your attorney?
No, ma'am, I did not receive a call from my attorney that I have record of, no.
Okay. 517-977-3560. Yeah, he left a voicemail, he says. Today was the date scheduled for probable cause conference. This is for receiving, concealing a motor vehicle, habitual third offense notice. And this matter is scheduled for exam in person at the court May 15th at 9 o'clock in the morning. Mr. Raleigh, did you get discovery?
I did, Your Honor.
Okay, and obviously you've not had an opportunity to meet with your client because you've not been in contact, but he is present and will give you an opportunity to log in today if you'd like to do that. Are we expecting to continue to examine this time?
Yes, Your Honor.
Is there an offer?
Yeah, the offer was to plead to the amended charge of a misdemeanor receiving and concealing 200 to 1,000.
Okay, so we'll see your client in person next week at 9 a.m. And then if you want to log in and meet with him, you can do so at this time.
Yes, thank you, Your Honor.
Thank you. And we still don't got Mr. No, Mr. I was talking about Mr. Blackman. He was on, but I don't know what happened. And then Danton Elliot is Mr. Etheridge as well. Black this as evidence. Let's see. Mr. Morris is not here. Just at the bag.
Hey, my screen is frozen.
How can we help you, Mr. Macon? Was that him?
You're good. You're just not,
Oh, okay.
you're just observing everything else. But I guess you wanna sign on. Have you talked to anybody yet? Not yet. Okay, you're good. Thank you. I'll make sure I get you track. Sounds good.
Is that
Appreciate it.
Mr. Who is that talking? Is it in the Elliott matter? Because it's dark. Oh.
Yes, sorry, that was my CO, Your Honor. My honor.
Damn it, just.
Now?
Hey, it's dark in there. Put in waiting room and start it over.
Hey, actually got
I can't see still. It's not coming up there either. No. Mr. Elliott's camera is frozen.
Yeah, can you hear me?
We can hear you,
Ma'am?
but your device seems to be frozen. Is there a deputy there?
I just got one. He's coming in right now. Yeah, it's froze. You can't see me. Can't see? No.
No, it's frozen.
All right,
Mr. Carter, are you ready with Mr. Macon?
I think the prosecutor's next.
Oh, which prosecutor's on now?
Now.
Okay.
We're going to need a new date for the agreement.
Oh.
Should I
Mr.
coordinate that now?
Well, we probably need the prosecutor, so, because her schedule.
She's on the
different.
record. I'll grab her. When she gets off, I'll let her know.
Mr. Etheridge just peeked in and walked out, but he needs to come in here. Mr. Etheridge.
Eric.
Mr. Etheridge,
Yes, Your Honor.
you. Are representing Mr. Elliott, correct? Elliott,
Elliot.
Danton Elliot.
Yes, Your Honor.
They're trying to fix this camera. It looks like they logged off just now, so they're probably gonna log back on.
The petition for the forensics referral was submitted last week, or according to my staff's paralegal.
Okay.
And I understood that was sent. That. Come on off, we'll pick your. Here.
It was, so why was it still in the document? Okay, Mr. Elliott's all set. Actually, it says it's set for forensic on August 6th for review at 8:30. Okay. Probably what they just sent it over. You're all set on that one. We're just waiting for your other client.
Yes, Your Honor, I did call him like 5 minutes ago, and he said it would be around 15 minutes, but he was on the way.
Mr. Elliott's all set.
Sorry, Your Honor, I lost connection. What was the outcome?
You were referred to a competency evaluation.
We know when that's gonna be, by chance?
The forensic center has to set that.
Okay, thank you, Your Honor.
You're welcome. What happened to Mr. Blackman? Says Brett apologizes, but he had to go into Jackson Circuit Court. He said he can walk back in about 45 minutes if that works. Sorry, please let me know.
Yeah.
Yeah.
I think from what March Mina says. We have just gone to a different. So this is- not only you just go to-
You might need this file back. With the, amendment motion. Modified. I might need the file back. Yeah. It's from today. I think I put it in. Okay, I never touched it. It's like today, but they. Oh, yeah, it was crossed off.
No, I'm just coming for a. I have a meeting with Mr. Carter. I thought you were. Did I not talk to you correctly? Or hear you correctly? I thought you were talking to him about it.
George is doing that.
George is doing it. Okay, well, I'm sorry.
I did your card. You want me to get a card?
I thought, yeah.
I just saw him in the room.
Well,
something.
Oh, no. He said, yep. He said, yes. No, I appreciate it. No, I was, yeah.
So. Maybe I accidentally did that.
I'm gonna resend the link.
But if I do a search, it would have showed up in the basket too, so I don't think I got it. Something happened.
On the record, in the matter of the state of Michigan versus Tahmeyes Macon, 26-00864, parents case.
Good morning, Your Honor. Natalie Macon on behalf of the people.
May it please the court, David B. Carter Jr. on behalf of Macon, Mr. Macon, who is a juvenile and he is zooming in from the youth center. I would waive his personal appearance and I have no objections to holding this hearing with, through this media with my client.
This was a matter scheduled today for probable cause conference. This is assault with an intent to murder, carrying concealed weapon and felony firearm charge. It's originally scheduled for examination on the 15th of May at 9:30. My understanding is that the parties are not prepared to proceed on that date and time.
That is correct, Your Honor. I would be asking for an adjournment on that. Although I was able to go out to talk to my client, he was reluctant to communicate with me without his parents giving the okay. Not only that, there is some video evidence that is material to this case that I have not been able to receive yet or go over with my client.
Okay. Have you since gotten the parents' permission?
Yes.
Okay.
I hope so. They told me, I met with them today, I talked to them, and they said that they will instruct my client to go ahead and talk to me.
Okay, and there's some additional discovery.
That is correct.
Okay. So how much time do you think you need to have this reset? And then how long do we think the exam is going to be?
Now, as far as the exam goes, I would guess with cross-examination no later than longer than an hour.
Oh.
Yeah, I would say it's relatively, according to the police report that I've seen, I don't think it's very fact
Okay, so
heavy.
how long would you think it'll take for you to get your discovery and have time to review it?
I think within a week.
So then you would be ready next week, no?
Well, I meant an additional.
Oh, okay.
Yeah, that
got it. Okay.
Because
so-
I'll need to rearrange my schedule, get out there and talk to him yet again with the
Got
videos.
Makes sense. Okay, typically I would advise or inquire of your client to ask him to waive the timeline due to his age and the circumstances. I'm gonna find good cause.
Thank you, Your Honor. And I would, as an officer of the court, I did talk to his parents. I told them what I would be requesting, and they were totally on board with that.
Unfortunately, the parents can't waive it,
I
so
know.
we would need the minor to waive it, and I think it's rightfully so. He wanted to get with his parents before he had any discussions. How old is he exactly? He is it 7th grade? I can't read the handwriting. Or 9th grade.
He's born in 2011, he is 15 then.
Okay, so it should be, it looks like maybe that's supposed to be 9th grade. I don't know.
Are you 15, Mr. Macon?
Yes.
Okay. Okay, so again, due to his age, the court will find good cause based on the circumstances presented in the court to go beyond the 21-day timeline to have this matter reset so that counsel can get the additional discovery and have time to schedule a meeting with Mr. Macon to go over that discovery. And I'm sure, of course, his parents would obviously want to have some follow-ups with you considering his age. So that'll take time as well. So with that being said, we'll set it for our next available date. June 18th at 9:30. Does that work for you, Ms.?
I didn't hear the date.
June 18th?
I think I'm actually on vacation, and I am. Atheme.
You do June 25th. June 25th at 9:30.
I can make that work.
June 25th at 9:30 in person at the court for examination. Let's see. He's got a $750,000 cash surety bond, and he's currently housed at the youth center. And they have indicated that they can care for him and keep others safe while he's there. So I don't see any reason to address or change the bond at this time.
Not at this time. If I believe that there is an issue there, I will file an appropriate motion.
Very good. Bond asset will continue Do you have any questions for the court today, Mr. Macon?
No.
Any additional matters for the record, counsel?
No, Your Honor, thank you.
No, thank you, Your Honor.
Thank you. You're all set.
Thank you.
Good day, Judge. You too. Good weekend too. Mr. Macon, you can let them know you're all set.
Okay.
Thank you.
I'm done.
Oh, okay, that's Mr. Blackman. Okay, yeah. This is the state of Michigan versus Jawan Edwards, 25-03044. Appearance, please.
Thank you, Your Honor. May I please the court assistant prosecuting attorney Dan Smith, appear on behalf of the people?
Your Honor, Fred Blackman on behalf of Mr. Edwards.
Okay, so this matter was scheduled for a probable cause conference today. This was a new probable cause conference date. The exam is scheduled for May 15th at 9 a.m. Are we continuing to exam?
I'll let the assistant prosecutor address that. He said that we needed an adjournment because of an officer not being available.
Today?
Adjournment of the exam?
I think the offer is to plead to 2 counts of.
No, what about the exam? Is the officer available for next week?
For next week. The officer is gonna be, yes, out of Officer Burnham is gonna be out of the country until June 30th.
Yeah, that's what he said. You gotta address it because your officer's not available.
Okay. But I thought originally he was gonna waive, but if he wants to run the exam now, yes, the officer is gonna be out until June 30th.
What officer is it?
Trooper, his last name is spelled Braun.
Okay, out until June
30th.
We probably read the timeline. We'll reset this until after that.
Yes, he has.
We can do July 9th at 9:30. July 9th work for you, Mr. Blackman, at 9:30?
It does, Your Honor. Thank you.
Okay, we'll reset to that date and time. We'll see you in person on July 9th. Any additional matters for the record?
Nothing from the people.
Nothing.
Thank you.
Nothing for us. Thank you, Judge.
Thank you. Is Mr. Trevino here? Or he was, but not anymore. Well, that was just on our contact orders without them here. So that's that. This is State of Michigan versus Daryl Morris, 25-03133. Of your appearance, please.
Thank you, Your Honor. May it please the court, Assistant Prosecuting Attorney Dan Smith, appearing on behalf of the people.
Good morning, Your Honor. Attorney Durkett, and also the public defender on behalf of Mr. Morris is in the courtroom standing to my right.
Mr. Morris has the operating while intoxicated third offense that was scheduled today for an, I believe, for probable cause conference. Looks like, however, it says he picked up another OWI. I was screened for sobriety, but what is this? Yes, OWI third, I have it here. File number 26-01100. Felony complaint here that alleges that on or about February 19, 2026, at the area of North Pennsylvania and Persons Court, which is in Lansing, Michigan, Lansing, Michigan, Ingham County, that you did allegedly in count 1 commit the act of operating while intoxicated or impaired. There's a third or subsequent offense notice attached to count 1. It said the defendant did operate a vehicle upon a highway, that being North Pennsylvania Avenue, while under the influence of alcohol, liquor, and or having an alcohol content of 0.08 grams or more per 100 milliliters of blood, contrary to Michigan Compiled Law 257.6251. That's a misdemeanor normally. Maximum penalty is 93 days and or $100 to $500 of fines and or 360 hours of community service and rehabilitative programs, and vehicle immobilization is mandatory with a prior conviction, and cost of prosecution reimbursement to government for emergency response and expenses for prosecuting the defendant may be ordered. There is, however, again, a third or subsequent offense notice, which enhances the count 1 to a felony. Says take notice that the defendant was previously convicted of operating while impaired on or about February 12th, 2009 in the 55th District Court, and of operating while impaired on or about September 10th, 2009 in the 55th District Court. Therefore, upon conviction, the defendant will be subject to an enhanced sentence under MCL 257.6259 or MCL 257.62511, and vehicle forfeiture under MCL 257.625N. That's a felony. Maximum penalty is $500 to $5,000 in fines in either 1 to 5 years or probation with 30 days to 1 year in jail, at least 48 hours to be served consecutively, and 60 to 180 days of community service, rehabilitative programs, and cost of prosecution reimbursement to the government for emergency response and expenses for prosecuting the defendant may be ordered. There is a mandatory vehicle immobilization of not less than 1 year or more than 3 years unless the vehicle is ordered forfeited under MCL 257.625N, and a term of imprisonment imposed must not be suspended unless the defendant agrees to participate in a specialty court program and successfully completes the program. Do you understand the charge and the maximum penalty as well as the enhancement? You have the right to counsel. You have the right to a public defender. If you can't afford to hire an attorney, you can make a request to have the public defense represent you at the expense of the public. Again, this is being enhanced to a felony, so you have the right to have a preliminary examination within 21 days of today's date, unless you waive the timeline or the court finds good cause to go beyond the 21 days. At the time of the exam, you have the right to have the prosecution establish that they have sufficient probable cause. You can remove your hands from your pocket in court. Thank you. A sufficient probable cause that a felony was committed, and probable cause sufficient to charge you as the individual who committed the felony. If this matter continues beyond the preliminary examination, you have the right to trial, the right to a jury trial, the right to be presumed innocent until proven guilty, the right to maintain your silence and have the prosecution call witnesses that you can cross-examine at court or question, the right to subpoena witnesses that will testify on your behalf, and the right to not have the silence be used against you. You understand that? He's requesting public defender on this one as well, correct?
Yes, Your Honor.
We'll enter a plea of not guilty on your behalf. You're currently scheduled for probable cause conference before me on May 22nd at 8:30. You have a preliminary examination May 29th at 8:30. Both are scheduled for in-person appearance, okay? Again, the court is into a not guilty plea on your behalf. Is your address changed from the Paris address? What's your phone number? 517-226. Where are you employed? West Rock? Yes. What is that? It's a freight company. Okay, so the allegation or the alleged date of this is February 19th, which is the date he was arraigned on this one, so. It's not a bond condition issue on this. This was probably just waiting for the lab results or something.
Your Honor, I'm not sure of the status of what they were waiting on to issue it. I do know that we adjourned your original case several times because he has been accepted into sobriety court. And we've already worked out a package deal and we're waiting on this case to be issued and him be arraigned. So both cases can go to Judge Buchanan and be set for a plea in sobriety court. It's my understanding the plea agreement would entail one of the files being dismissed and being pleaded to the other file.
Yeah, it was waiting for lab results. He was arrested on the drunk driving in 26-01100 February 19th. But it looks like the file number ending in 3133 was already pending. He had failed to appear for arraignment. So they arraigned him while they had him in custody, but they still needed lab results on this one. So I was just trying to see if this was picked up while he was on bond, but that's not what happened. So both of these matters are supposed to be transferred to Judge Buchanan for sobriety court.
Yes, Your Honor.
Okay. Our bond conditions will be identical to the conditions in the previous file. He's not to travel outside the state without prior approval of the court. He's not to use drugs or alcohol, not to possess a firearm, ammunition, or weapon of any kind. He is going to be required to participate in random weekly preliminary breath testing. 2 random ETGs monthly. Does he already have a date when he's gonna be before we can? They have to do that. Okay. I just know this was to be transferred. She takes the plea anyway, so. I hope that this will be transferred to a sobriety court. You'll enter a plea before Judge Buchanan, okay? Any additional matters for the record?
Nothing from the people, Your Honor.
For the bond, Your Honor, what was the bond?
The bond is set, again, identical to the other 750 personal recognizance.
All right, thank you, Your Honor. No further questions.
No problem.
So concept can be developed.
Did he do fingerprints on
He
this?
has to do fingerprints.
Okay, he has to hang tight because he's got to get fingerprinted and we gotta get a bond processed on this.
All right, thank you, Your Honor. Just have a seat on the bench outside and the court also. Your Honor, regarding Mr. Trevino, he appeared earlier by video and then after we released the bond issue, came up with changing the bond condition.
I'm not changing no contact order, he's not present.
Yes, physically present or by phone or by video, Your Honor.
Video's fine.
I'll try to get him back on the video, Your Honor.
You need a moment. You can do that. And you're here for Jessica Bai?
Yes, sir.
Okay, you can get set up when we're finished dealing with that. We'll call your case.
Run to the bathroom.
Absolutely. Gotta take her seat. All set. Mr. Colis, are you all set with your pretrial?
Yes, Your Honor. I emailed to your clerk the pretrial statement that we worked through together in the breakout room.
Very good. And then, Ms. Kemp, did you have any questions about that?
I asked all of them, and I think I have an understanding of what's going forward.
Okay, so once we receive that, I review and sign it, and that will be what the clerk's office is used to generate your next court dates, okay?
Okay.
Thank you very
So
much.
you
Your Honor.
received that, yeah, thank you. You're all set.
Thank you.
Thank you.
You're welcome.
Whoa. Whoa. Yeah,
Yeah. I'm hoping I hear that one.
This is the matter of the state of Michigan versus Dominic Trevino, 6-01131 appearances.
Assistant Prosecuting Attorney Dan Smith appearing on behalf of the people.
Good morning, Your Honor. Attorney Derek Ether from the Office of the Public Defender on behalf of Mr. Trevino. Mr. Trevino is appearing by video.
Okay, there was a motion or a stipulated order to modify the bond. The defendant currently is on bond for home invasion first, and interfering with a crime report, electronic communication, domestic violence, and malicious destruction of property. Defendant Well, there's a complaining witness of Samantha Bishop. Looks like there's a no contact order. They have minor or a minor child or more than one. There's minor children.
I believe they just have one minor child in common.
Is there a family court order?
There is not a family court order at this time.
Did he have another criminal matter pending?
Your Honor, I believe he's pled, I think in front of this court in domestic violence with 76948 is scheduled for sentencing with Miss Rob.
Same victim.
I'm not sure of that, Your Honor. I don't have the misdemeanor. I'll defer to Mr. Smith.
It's the same victim.
No, this
The motion's denied. I'm not, he's got to get a court order from the family court if he wants to communicate about the child at this point.
Okay. I'll let the complaining witness know.
Thank you.
All right, Mr. Trevino, the court has denied the prosecutor and the alleged victim's request and motion. So please continue to follow your current bond conditions, okay?
Okay, thank you.
Yes, sir.
State of Michigan versus Jessica Lynn By 26-00146 Harrisburg.
Thank you, Your Honor. May it please the court. Assistant Prosecutor Attorney Dan Smith appearing on behalf of the people of the state of Michigan.
Kyle Strobridge on behalf of Ms. By.
Okay, this was the date that was scheduled for a preliminary examination. There was also a motion that was filed. The defense filed a motion to suppress the evidence and dismiss the case. The people filed a response. My understanding is that we have officers present to take testimony on the argument. Is that correct?
That is my understanding.
Yes.
Any preliminary matters before we proceed?
Your Honor, we just asked that if it's for just judicial economy for after the evidentiary hearing, if you could rule on the bind over matter, so we don't have to reschedule a testimony a second.
We're doing it all today.
Okay.
That's the reason why we wouldn't.
That was my request, Your Honor, to hear all the testimony and then rule separately on the motion.
Sounds good. I'm sure it's all the same information.
That's
so
correct.
Thank you. You can proceed.
The people call Stephanie Randall.
Do we have more than one witness in the courtroom? Oh. Other right hands? Please solemnly swear or affirm testimony you're going to give us the truth and the whole truth under penalty of perjury. Yes. Okay, you can have a seat. You can state your first and last name and spell both.
Stephanie Ringo, SEFANIE RANDALL.
There's a microphone that's in front of you. That microphone will not amplify your voice. So if you can keep your voice as loud as possible, that would be great. If either of the attorneys make an objection, you will stop speaking immediately. I will make a ruling on that objection, and then I will tell you if you're allowed to answer the question or not, okay? If you have a question posed to you that calls for a yes or no answer, you must answer yes or no. A no head nods, head shakes, because we can't articulate that into the record. So if you forget, I'll just ask you if that's a yes or no, okay? Okay, you can proceed. Counsel.
Thank you, Your Honor. Good afternoon, Ms. Randall. How are you? Good. Good. I know it's a little bit of a bummer to be in court under these circumstances, but I'm hopefully get you out of here pretty quick, and let's just talk about the matter that brings you to court today, right? So first, I want to start off by asking, on November 9th, 2025, were you involved in an accident that was near Martin Luther King and Olds Avenue?
Yes.
And can you tell us, can you describe for us, just in your own words, what happened at that accident?
I had just picked up my wife to work, and we're driving. I just glanced down at my speedometer, and I looked up and collided with the person who ran the.
Okay. And did this accident happen in the city of Lansing?
Yes.
Ingham County?
Yes.
State of Michigan?
Yes.
Okay. And where were you going to? You said you just picked up your wife?
Yes.
Where were you guys going, heading to after you picked her up?
Excuse me? Can you speak up a little bit for me?
I'm sorry. We were going home.
And you said the individual ran the stop sign? And then you said you.
Don't object to that speculation, whether she ran it or stopped and proceeded.
Call speculation.
Speculation.
Okay. Did you see her run the stop sign, ma'am?
Yes, because when I glanced up, I saw her going much faster, and I didn't have time to stop.
You saw her going much faster?
Yes, she was fast. Like, she didn't stop at the stop sign, and there was me and a bunch of other cars behind us. It was a one-way street, and I just saw her go right in front of us.
Okay, so what your testimony is that you were able to visualize her as she approached the stop sign, and
She
then
was already, sorry.
You gotta wait until she's done.
as she approached the stop sign, and that you also visualized her just not stop and continue to go through, or did you take your eyes off her and the next thing you noticed is that she was through the stop sign?
I had glanced down at my speedometer and looked up and just saw the car SUV going past the stop sign.
So did you see her stop at the stop sign or no?
Did you see her prior to she got to her getting to the stop sign?
I had saw the car on Old Road because I was one of the first cars in like the wall of traffic. And when I glanced down, I had made sure everything was fine, glanced down, glanced up, and that's when I signed on the brakes.
I'm going to sustain the objection because I believe it does cause for speculation.
And the individual that you saw in the SUV, is that individual present in court today?
I don't know. I never saw it.
Okay. Okay, so after the individual came to the stop sign, what happened next?
I remember the impact. And then somebody was talking to me. I think it was the other lady that got hit. I just remember trying to get out of the car. I thought it was on fire. I didn't have my glasses on anymore. And I couldn't see very good. I tried to get out of the car and couldn't. And that's when my leg was broken. And then the paramedics got me into the ambulance.
take a minute if you need me, okay? Yeah, no problem. I know it's hard to recount that, so just take a minute.
Answer your question.
Yeah, no problem. So as a result of the accident, did you sustain an injury?
Yes, my tibia, I had an open fracture of my tibia and my tibia.
And were you transported to the hospital as a result of the accident?
Yes.
And how long were you in the hospital?
A week. About a week. On the 10th, I had surgery. I'm
up.
so sorry.
Yeah, no
Yeah,
problem.
it was a week.
Okay. And what type of surgery did you have?
They put a rod through my tibia and just rod and screws and where the bone coming out.
And you were in the hospital for a week, you said?
The first time. The second time I was in for another week because I got an infection from where the bone had broken the skin. So we had to do another surgery.
And how long were you in the hospital that time?
Also
A week. And I would imagine this was very painful.
Objection.
I think that's a question.
It's
though.
not a question.
Yeah, is it a question?
Was this the breaking of your leg? Was that painful?
Yes.
So at this time, have you healed from the accident?
I'm still going through physical therapy and I have another appointment with my ortho and the disease specialist on Tuesday.
Did you were you prescribed any medication based off of?
Yes, I had to have a PICC line for 6 weeks for the antibiotics for the Staphylococcus aureus that I got from the initial break.
And how's the accident affected your life?
It's changed pretty much everything. I haven't been able to function like normal. I just now started walking without a cane.
Take your time.
It's changed everything. Bathing, getting dressed. And it's a day by day thing, even though it's been 6 months, it's still hard to sometimes get up, and do normal things, even if it's going to get a drink of water. Being in a car is terrifying.
And last question, how long is did they say the rehab for your break? How long is that?
I have, they reevaluate me every 4 weeks. But so far it's been ongoing since February.
So there's no definite date.
No.
Okay, no further questions.
I have no questions, Your Honor.
Okay, you make the excuse, and thank you. Thank you. Please pardon us for this.
People call Officer Haven Hyatt. There's some black chair. She was ready to not see it.
You solemnly swear or affirm the testimony you're going to give us the truth and the whole truth under penalty of perjury.
Yes, ma'am.
United States. You state your first and last name and spell both.
First name is Haven, last name is Hyatt, H-A-V is in Victor, E-N is in Nora, H-I is in Ida, A, two T's is in Tom.
Thank you, Your Honor. Officer Hyatt, I understand that you were recently married.
Yes.
Congratulations.
Thank you.
So hopefully we'll be able to get you back out of here pretty quickly, and so you can continue that honeymoon period. So I'm gonna need to
Are you
pull
on
up
the
the body
Zoom?
camera.
Are you in the Zoom room?
Yes.
Okay. Thank you. See.
Officer Hyatt, are you currently employed?
I am,
And where are you employed?
Lansing Police Department,
How long have you been a police officer with Lansing Police?
almost 2.5 years.
And what are your duties as a Lansing Police?
I'm a patrol officer, so I respond to calls on the road, whether it be trouble subjects, crashes, anything of that nature.
And do you have any experience with OWI investigations?
I do.
Can you tell us about your, do you have any training with of the OWIs?
Yeah, I am a ride certified.
Tell the court what that is.
So basically, it's just a certification that takes you through extra steps on how to investigate in OWI. It just goes through and make sure that you're certified through Michigan standards.
And when were you last certified in that?
Last year.
Last year? Okay. And how do you know how long that certification lasts for?
I don't.
All right, okay. So I'm gonna direct your attention to November 9th, 2025. Were you on duty on that day?
I was.
Did your tour of duty take you to the intersection of South Martin Luther King and Old Avenue?
It did.
And is that in the city of Lansing?
It is.
Ingham County?
Yes.
State of Michigan?
Yes.
On that time, at that date and the location, were you involved in a vehicle accident investigation?
Yes.
Do you see someone present in court that you encountered on that day?
I do.
Can you point that individual out and describe an article of clothing?
It's just by wearing black.
Your Honor, let the record reflect that the witnesses identified the defendant.
We need objection to identification.
No, Your Honor.
Identification submitted.
And can you just tell us briefly the nature of the call that brought you to that location?
It was dispatched as a 3-car accident in the intersection of King and Olds. So that someone was injured and they weren't sure on consciousness levels.
And were you wearing a body worn camera during that day?
Yes.
Would you recognize it if I showed you a still caption of it?
Yes.
Your Honor, I'd like to introduce what's going to be marked as People's Exhibit 1, Officer Hyatt's body worn camera.
Any objection?
No.
Yeah, exhibit 1 is it better?
Hey, that's me.
Oh, keep your computer muted. That'll stop the feedback. But when you go to share, you click share sound. It should be on the side. It says share sound. Are you on share screen? If you could bring your computer to me, I'll show you what to do. Go to share screen. It's right there, share. And then share sound is on the side. You click that, and then you'll click whatever video you're trying to share. It's not playing. Can you click play? It's up on our screen.
Okay, and for the record, I'm starting Officer Hyde's body worn camera at 2 minutes and 50 seconds. Officer Hyatt, do you recall this portion of your body? Well, is this does this accurately reflect your body worn camera on March on November 9th, 2025?
Yes.
And what do we see here?
You can see the first vehicle when I arrived, which, and the other, it's hard to see in this, but there's two vehicles on the other side of that silver sedan.
And I'm gonna play a few clips. I'm not gonna play the entire thing. I'm gonna omit the entire video. I'm gonna play some clips and just have you describe.
Okay.
Share sound.
My sound doesn't work when I play it on that. I have to play it at home. I don't know why. Let's see.
Do you have any head pain or anything like that, sweetheart? Left leg, chest pain, and a possible head injury. Can you copy a plate? David, X-ray David, 7341. Can you copy a temp plate? Who is in this car? Okay. 9258 Robert 20. It's gonna be black in color. The first one I gave you is silver. Okay, are you injured at all?
It's just like my ankle hurts a little bit, but I think I am fine. Bowie, do you hurt anywhere? No. You're just upset, yeah.
Okay, give me just a second so I can check on them, okay? 24, copy a third. It's gonna be David, Mary, Victor, 733. It's gonna be teal. We're gonna need flatbeds for all of them. Okay,
So,
were you in this car?
I was on the driver.
Are you okay?
I have some minor bruising and my passenger has some minor bruising, but I think we're fine.
Okay, but you guys are good?
Yeah.
Did you hit your heads or anything like that?
We had air flags deploy all the way around, so I think we're okay.
Okay. Was he in the car with you or was he just?
No.
Were you in the other one?
Two of us.
I was just stopping by to make sure everybody was okay.
Okay. Did you see what happened?
No, I didn't see anything that happened. I
Okay.
just noticed that there was cars
Okay.
racing around.
All right. Thank you. Do you guys have your IDs on you?
I'm gonna pause the video at 4 minutes of 30. Officer Hyde, does this accurately describe what you encountered on, did this accurately depict the accident as you saw it on November 9th?
Yes.
And back it up a little bit and ask you if you can identify a few people. Here. Do you remember who these individuals were here that you see on screen?
I don't remember their names, but I do recognize the lady in the shirt. It was right at the sweatshirt.
And okay. Do you remember who this individual is here?
In the pink plaid shirt is Miss Jessica By, standing next to Isidoro.
And what vehicle was she driving?
the black SUV.
Do you remember the names of these two individuals?
The short hair is Miss Cheryl. I don't recall the last name, and I don't recall the other name.
And I'll play this portion with some sound and then ask a question.
Were you in this car?
I was on the driver.
Are you okay?
I have some minor bruising and my passenger
Are you-
has some minor bruising, but I think we're fine.
Okay, but you guys are good. Did
Yeah.
you hit your heads or anything like that?
We had air flags deploy all the way around, so I
Okay.
think we're okay.
Okay. Was he in the car with you, or is he just?
No.
Were you in the other one?
Two of us.
I was just stopping by to make sure everybody was okay.
Okay. Did you see what happened?
No, I didn't see anything that happened. I
Okay.
just noticed that there was cars facing
Okay.
around.
All right. Thank you. Do you guys have your IDs on you?
Nobody goes through here? Or?
No.
So this individual here, she was just involved in that. That individual there, was she the driver of the blue car?
The female?
Yes.
That's it, yes.
In my phone, but I didn't see where it went.
Okay. If you're
We're gonna get you checked out.
Were you able to find your ID?
Yes.
Okay.
She told you how fast she was going southbound.
Which one? No, I didn't talk to the silver car.
Okay.
I talked to blue car. Jones right there, the one that's walking this way, he talked to a silver car.
Sorry.
No, you're good. Miss Jessica, what's your phone number?
My phone number is 517-763-5625.
5625?
Yes.
Okay. Can you kind of tell me what happened today?
I think that I was distracted. I was having a conversation with my kid and we were driving. I assume that I must have missed traffic coming
Okay, which way were you going?
across here.
Okay, so you were on Olds going
Yes.
across King?
Yes.
Okay, did you come to a stop at that stop sign?
Honestly, I feel insanely shooken up. I don't know. Like I I just was driving regularly, and then all of a sudden I was in an accident. In my perspective.
Okay. Did you have your seatbelt on?
Yes.
Okay. And then where was she sitting at?
Bowie was in the passenger seat.
In the front seat?
Yes.
Okay. Can you spell her first name for me?
Yeah, Bowie, Bowie.
What's her middle name?
Jay.
Last name?
Metzger, Metzger.
What's her date of birth?
5/28/2005. However, some of their paperwork hasn't, like, we have been working on a name change, so that some of their paperwork hasn't gone through, so
Okay,
they
is this
might
her
be
legal-
listed. Well, that is the legal name, but we haven't gotten it, okay, so, I believe it to be the legal name currently, but their, birth name is Clementine Elise Metzger.
Bowie, were you wearing your seatbelt?
Yeah.
Yeah. Okay. Do you have a phone number at all?
They do. I have it in my phone. I'm sorry. No, it's not your fault. I messed up. I don't know what I did. I don't even know. This is so confusing.
Miss Jessica, I just have to ask, okay, because I have to ask everybody, okay? Have you been drinking at all today?
I did go to, I did, oh, God.
24, does anyone have a PBT?
I did go to, Cypher.
Are you hurt?
And had a drink
Oh,
there
shit,
at a Long Island iced tea, like,
It happens.
2 hours ago.
Okay, so 2 hours ago you had a Long Island iced tea?
Yeah, or I ordered one 2 hours ago.
Okay.
Okay. Do you have a PBT?
Alcohol's got your vitals there already, so.
Get him out. Man, we'll go to the ambulance, get you out of the cold for a little bit. How about that?
Thank you.
Watch your shoelace.
Did you get their phone number?
I did.
Okay.
Did you have anything else to drink?
No.
Okay. So you had one drink and it was a Long Island iced tea. It was about 2 hours ago?
Well, I ordered it 2 hours ago, and over the course of 2 hours,
Okay, so you had one drink and that was it?
yeah.
Okay.
But stupid drink. Oh my God.
Okay. All right. Give me just a second. Why don't you get in that ambulance with Bowie, okay? Just that way you can warm up, all right? I'm gonna go run her first, and then I'll do that. She said she drank 2 hours ago, had a Long Island. I don't have a sense of smell, I'm sick. But she's kind of talking, like, kind of, yeah, like the typical girl who's had a drink. Ambulance with Chloe, okay? Just that way you can warm up, alright? Yeah, she's in here. You can just go in the, yep, right through that one. Yep. I'm gonna go run her first, and then I'll do that. She said she drank 2 hours ago, had a Long Island iced tea. I don't have a sense of smell, I'm sick. But she's kind of talking, like, kind of, yeah, like the typical girl who's had a drink. She didn't really look me in the eyes at all during that. So I'm gonna go run her and make sure she doesn't have any previous oils, and then I'll be right back.
Are you gonna have my UTM number?
Your UD10? Yeah, I can. Yeah, it's me. $24 to $25.
Isidoro. 39-year-old female.
Yes.
I'm sorry, I forgot to get Jessica's insurance information. Are you able to do that? She's she's Subaru lady. So I guess if it's in her, she's the possible OUI.
Okay. So she got it in there. Anything? All right, I'm gonna just set this right here. You can smell it.
You can?
I can smell it.
Okay.
A little bit.
Okay. All right. So what I'm gonna do is I'm gonna come over here, okay, to this line. Just gonna borrow this for a second. All right, just because you told me that you have been drinking today, I do have to perform. SFSTs, okay? So SFSTs means a field sobriety test, okay?
Okay.
Give me just 1 second. 24, I'm sorry, SFSTs. Okay. So what I'm gonna do is I'm gonna do what's called the HGN, okay? I have to ask you a few questions, okay?
Is this a-
I'm starting SFSTs. What? Can you let them know? Okay. Okay, yeah. Okay.
What's that mean?
SFSTs means...
No, I mean, why did you shake his head? Did something?
No, they were just...
Different thing.
Different thing. So... to ask you a few questions, okay?
I have asthma. I have a thyroid condition. Scoliosis.
Okay. Do you have anything that would prevent you from walking normally, standing on 1 foot?
No.
Okay. Any issues with your eyes or anything like that? Cataracts, glaucoma,
I mean,
anything?
I have astigmatism. but
Okay.
nothing like crazy with my eyes.
Okay. Do you wear contacts or glasses?
No.
Okay. Are you wearing contacts or glasses right now?
No.
Okay. All right. So what I'm going to do is what it's called horizontal gaze nystagmus. Okay. So what I want you to do is I want you to look at the tip of this pen, follow the tip of the pen with your eyes and your eyes only. Okay. Do you understand?
Yes.
All right. All right. Again, only with your eyes and your eyes only. Look at the tip of your pen. Follow it. Okay. I'm gonna have you turn this way so that way the flashing lights aren't in your eye. Okay. All right. We're gonna try this again. All right. Again, only with your eyes and your eyes only. Look at the tip of the pen. All right, the next one that I'm going to have you do is the one leg stand, okay? So what I want you to do is put both your feet together like this, put your arms Hands out to your side just like this. I know it's cold. Just keep your hands out of your pockets till we do this, okay? All right, just stay in that position until I tell you to do something else, okay? So then what I'm gonna have you do, when I tell you to,
Do you mind if I move on to like a more steady?
yeah, no, you can come over here. Let's come over here, like right here.
Sorry.
No, you're
it's, like,
good.
Split in the middle.
No,
right
you're
where
good,
I
okay?
was. I'm sorry.
You keep your feet together, hands at your sides, okay? Don't begin until I tell you to, okay? So when I do, you're gonna put your foot up, either one that you choose. I'm gonna choose my right, okay? You're gonna lift it 6 inches off the ground. You're gonna point your toe, keep it parallel to the ground. You're gonna do 1, 1,000, 2, 1,000, 3, 1,000 until I tell you to stop, okay? Does that make sense?
Yep.
All right, give me just 1 second. All right, and then again, hands at your side just like this. Yep, perfect. All right, when I tell you to begin, I want you to begin, okay? 1, 2, 3, begin. Count out loud.
1, 1,000, 2, 1,000, 3, 1,000, 4, 1,000, 5, 1,000, 6, 1,000, 7, 1,000. How many do I
Keep
count?
going
8,
until I tell you to stop.
1,000, 9, 1,000, 10, 1,000, 11, 1,000, 12, 1,000, 13, 1,000, 14, 1,000. Sorry.
Okay, keep going.
15, 1,000, 16, 1,000, 17, 1,000, 18, 1,000, 19, 1,000, 20, 1,000.
Okay, you can stop. Thank you. 30, 47. All right, then. The next one is called the walk and turn. Okay, so what I'm going to have you do is I'm going to have you use this white line, okay? Go ahead and stand on this white line for me just like this, feet together, okay? Take your right foot, put it in front of your left foot, heel the toe. Go ahead and do that right now.
Okay, right foot in front of left foot.
Heel the toe.
Sorry, this is my right hand. I have dyslexia.
All right, and then, nope, just, yep. Heel the toe like this, hands at your sides, stay like that until I tell you to stop, until I tell you to begin, okay? All right, so what I'm gonna have you do is I'm gonna have you take a series of 9 steps, heel the toe, and it's gonna look something like this, okay? 1, 2, 3, 4, so on until you get to 9, okay? When you get to your 9th step, you're gonna take a series of small turns, and you're gonna begin again. 1, 2, 3, and so on, okay?
Okay, I'm sorry.
Do you have any questions?
Yeah, I walked 9 steps and then I do like a full circle and tiny steps.
Yep, you take a series of small steps, and then you walk back another 9 steps.
Okay.
Okay, so again, it's gonna be heel the toe like this. 1, 2, 3, 4, so on. And then when you get to your 9th step, you're gonna take a series of small steps just like this. And you're gonna do again, 1, 2, 3, and so on. Until you get to 9 steps, okay?
Sure.
All right, do you understand my instructions?
I believe so. I
Okay,
believe so.
all
I
right,
believe so.
go ahead. You're gonna have to count out loud.
Sorry, okay. 1, 2, 3, 4, 5.
Hands at your sides.
6, 7, 8, 9. Then this is the series of small steps like this. So now I go backwards.
Yep.
And do another 9.
Correct.
Okay. 1, 2, 3, 4, 5, 6, 7, 8, 9.
Okay. You got that? All right. Miss Jessica, I'm gonna read this to you, okay? Michigan law requires that you submit to a preliminary breath analysis upon request of a peace officer. Your refusal to submit as requested shall result in you being charged with a civil infraction with a penalty of up to a $100 fine. Okay? Will you take a PBT for me?
I mean, like, honestly, like, I'll take the fine because I know that they can be inaccurate.
Okay, so just to clarify, on body camera, you're refusing to take a PBT.
Because they can be inaccurate, yes.
Okay.
Absolutely. I'll take the fine.
Okay, all right, well then you're gonna be under arrest for driving while intoxicated. Go ahead and put your hands behind your back and release your fingers like you're praying, all right?
You go check now, please.
Yes.
It might have been muted. You hear us?
Yeah.
Okay, thank you. It was muted. Just a moment.
I'm not a Zoom genius either, so
I have to give you permission to share your screen. Okay, let's see. I'm gonna share your screen. I'll make a co-host. And you know how to share screen? At the bottom of your Zoom, there's a share with the arrow pointing up in the middle of the Zoom.
Yep.
When you click that on the left, I mean the right side, it'll say share sound. There's a box. You should, so you'll click that and then it should populate to whatever you want to share, but that it has to already be open for it to populate. And then you click it. I hear an error. I hear.
Oh, what is it?
I'm like, I'm hearing myself repeat.
it's not playing yet.
It's my computer. What is going on with these computers today? Okay, this is what I'm gonna do. Did that address it? Check, test. I think that.
So it's not.
You can hear it?
No,
I
it's
can't.
not just you.
Yeah, I turned my volume down, so whatever.
I know there's a way to do it, to mute the computer, but
Oh, mine's is mute. My computer was playing back here, so we can hear it appear. I think yours should be fine. You keep your computer muted so it doesn't echo or
well,
give
that's what
that
I'm trying.
piercing.
It won't play the audio if my computer's muted though. Don't know why.
Mine's, no, I didn't mute mine. No, I just turned the computer on the actual, the computer volume down, but the Zoom, I'm not muted. There's supposed to be sound on this?
Yeah, I'm muted. So.
We're gonna need an additional medic. I do have another female here with possible.
Same issue, but we'll make it work.
Yeah, let me see what's going on here. Participants.
Yeah, I'm muted.
Yeah, he's muted in Zoom, man. I don't know why it's doing that.
Are you still in?
No, I'm out.
No, he is there, but he's muted. We'll make it work.
Okay. Okay. Good afternoon. Where'd you get married?
Are you gonna get a new last name? Oh, okay, good, because so I can know when search wants to come who you are.
Okay. Mr. Smith went through some of these, so we're gonna get caught up. Are you familiar with the field sobriety student manual that I'm holding? Okay. I'm assuming you use this as part of your training and certification. Okay, so we might be referring to that. I just wanted to establish that everybody knew what it is and you've used it before. All right. So I'm gonna go. Oh. So I'm going to go straight to the odor issue. Obviously, in your affidavit for search warrant, again, you've reviewed this. You need to see another copy of it again.
Yeah.
Okay, that's a. I'm going to give you this one just because it's not the same one you reviewed. That's a fair and accurate depiction of the search warrant as you wrote it up and submitted it. Your Honor, I'd like to move for admission of defendant's exhibits, exhibit 1, the affidavit for search warrant.
A. This exhibit A for you.
Objection.
Exhibit A is admitted.
So in there, in the middle, it said, I could smell the odor of intoxicants emanating from her breath. Is that accurate?
Yes.
Okay. And then on the video that we watched, you told your partner, Officer Jones?
Yes.
Okay. I don't have a sense of smell, I'm sick. No, that's accurate.
Yes.
Okay. That's different from I don't smell alcohol from her, correct?
Yes.
Not having a sense of smell means you can't smell anything. Okay. So when did your sense of smell come back?
When we went downwind.
Down. How far away were you?
From Miss By?
From Miss By, yeah.
It was during SFSTs.
It was during SFST.
During my 3 questions, I could smell it.
You said during the pre-questions?
Yes. When I was asking for the medical questions.
Okay. And you said that Officer Jones told you he could smell it. When was that?
Before SFST started. And I was running a finally.
And he had just come from inside the ambulance at that point. Fair enough. We're gonna move on to the field sobriety tests. You did ask Miss By if she had any medical conditions, right?
Yes.
What did she respond with?
She had asthma, thyroid issue, ADD, and scoliosis.
Would it be fair to add astigmatism in there as well? Do you remember that?
Yeah, during the contact portion.
Okay, fair enough. Do you know what scoliosis is?
It's the curvature of the spine.
Okay, and if you know, you know, if you don't, you don't. Can that affect affect the way a person walks?
Depending on the severity, yes.
Did you put any of that in your search warrant affidavit? The
Scoliosis
medical
portion?
conditions?
Don't recall.
Okay, well, we can let you look at it again. You can actually, you can hold on to it in case we need you to look at it again. I have another copy here. Did you put that in the search warrant?
I did not.
Okay, why not?
the ones that was relevant,
Okay,
ADD or asthma to being able to walk.
okay, what about the scoliosis?
She was walking around the scene during my time being out there. I think I began SSTs around the 30-minute mark of me being on scene. The entire time she's been walking around, I didn't appear to see any issues with her walking.
Okay, fair enough. So she responded negatively when you asked her, is there anything to prevent you from walking normally, right? Okay,
Or standing on one foot.
or standing on one foot, thank you. Is walking heel to toe a normal gait?
Normal.
A normal gait, like a normal way to walk?
No.
So we're gonna refer to this manual real quick. These field sobriety tests, how many are there? Standardized field sobriety tests? Three, okay. And we covered what those are, but can you say them again for me?
Horizontal gaze and segments, the one leg stand, and the walking train.
All right. And those tests are scientific in nature, are they not?
Yes.
Okay. And because they're scientific in nature, they have to be given the same way every time and recorded the same way every time?
No.
No.
Substantial compliance.
Substantial compliance, but the scientific method that we all learned at high school, if it's not repeatable, it's not trustworthy. Would that be accurate?
I guess I'm confused by your question.
So in order for something to be scientific, it has to be repeatable.
I would object.
What's the objection?
Relevance and I think lack of foundation.
I'll rephrase you.
Okay, object, he's withdrawn.
So, hand you the manual, section 8, page 12. There's a red tab there. Can you read or yeah, can you read that for me?
Out loud and myself.
Out loud would be great.
It is necessary to emphasize this validation applies only when the tests are administered in the prescribed and standardized manner. Standardized clues are used to assess the subject's performance. The standardized criteria are employed to interpret that performance. If any one of the SFST elements is changed, the validity may be compromised.
So if one of the elements is changed, the validity may be compromised. What's that mean to you?
Read, demonstrate, or offer instructions.
Okay, and would you include scoring them properly in that?
Like the clues?
Correct.
Okay.
Would you include that in that statement?
Yes.
Okay, all right. So we're gonna go back to the HGN. We're gonna go to 2849 on the video. What harder to do here? Oh. Call it 2832. So we already went over the instructions earlier. So I'm going to ask you, what are the clues on the HGN?
Lack of scope pursuit, maximum deviation, or next act is at maximum deviation, and the onset of next act is prior to 45 degrees.
Okay. All right. And when you're giving the test, how long does it take? So you start off with the pen, obviously we can see on the video. How far away is that pen supposed to be?
12 to 15.
Okay, looks fairly close. You start in the middle, and then how do you proceed to do the test?
Left eye first, and then right eye next. Do that for each test.
Okay, how long does it take for you to go from the middle to the maximum for one side, one eye?
You're saying for the maximum?
Well, sorry, when you're doing the test, you start it, it's a whole test. You start it and you run through the whole thing, correct? When you start with the pen in front of the eye and you go out to however far you go out and you come back to the center, how long is that supposed to take?
Approximately 2 seconds. Or
All right.
1/1000.
Okay. So correct me if I'm wrong, it should be 2 seconds all the way out and then 2 seconds back.
Like 1/1000. No, 1/1000, 2/1000, then right eye.
Okay. So again, let's go back to session 14, page 16 of that manual. I'm going to show you. Show you number 6 on there. It gives the instructions on how to do the HGN. Let me know when you're done reading that, please. So based on that instruction, it would take you a total of 4 seconds to go from middle out to your maximum and back to the middle. Is that accurate?
Approximately.
All right. And then you do that for the equal tracking, you do that twice, once for each eye.
Yeah, right eye, or I'm sorry, their left eye and left eye.
Okay, perfect. So that'd take roughly 8 seconds then, give or take. And then for the lack of smooth pursuit, that's essentially the same test as the equal tracking.
Yeah.
Same timing, same everything.
Yeah, equal tracking is not full free, just to make sure that she is able to do so. But smooth tracking is part of the H.
Perfect. And then when you're doing the nystagmus at maximum deviation, how do you conduct that?
Here to the pen to be able to bring it out until maximum deviation to see if there's any of the seconds.
How long do you hold the stimulus out at maximum deviation? And then for onset prior to 45 degrees, how do you conduct that?
Prior to 45 right now, and then 45.
How long is that test for each eye?
Approximately.
Are you supposed to do it for 4 seconds in each eye?
No.
Oh, we can, it's all right, we can use the cheat sheet. So all told, we add those all up, takes about 90 seconds to do the HGN. Would you agree with that? So we're going to type this up to the beginning of it. and play the HGM. Again, we're starting at what looks like 28:18.
It's called horizontal gaze nystagmus, okay? So what I want you to do, I want you to look at the tip of this pen, follow the tip of the pen with your eyes and your ears only, okay? Do you understand? All right. Again, only with your eyes and eyes only. Look at the tip of your pen, follow it, okay? We're gonna be turned this way so that way the flashing lights aren't in your eye.
So I just paused it. We're at 28:49. Why did you rotate her?
I can see that the red light, from my emergency lights was flashing in her eyeball. I didn't probably see correctly, and I didn't want her to be staring at lights.
Because that can affect the test. Right?
Okay. All right, we're gonna try this again. All right, again, only with your eyes and eyes only. All right, the next one I'm gonna have you do is.
I was talking to my computer to try and get it to pause. So that after you rotated her to get out of the lights, what we just watched was approximately 33 seconds. You agree with that?
Yes.
Okay. So it's well under the 90 seconds that you need to properly do an HGM. Now, based on those instructions that you reviewed earlier, is it correct that you're supposed to check each eye at least twice? Manual, I believe it's. So session 8, page 27, go ahead and review that. You don't need to read it out loud. Let me know when you're done. And those instructions, you can hold on to that. Those instructions indicate that you're supposed to check each eye at least twice.
Yes.
Okay, now we can go to the scoring of the HGN. Again, tell me how you should typically score that.
To clarify, I did not observe any nystagmus for the distinct and sustained or the onset. I didn't complete it twice because it was not there the first time.
Okay, fair enough. Good. Thank you for clarifying that. Moving on to the scoring, 4 or more clues indicates a likely BAC of 0.08 or higher. Is that correct? Okay, so 2 clues would indicate a BAC under 0.08. Did you put that in your search warrant affidavit?
I observed in the pursuit. That's it. During HGN, I observed a lack of some pursuit of bias. I didn't know the others.
All right, let's move on to the one-legged stand. All right, again, what are the scoreable clues on this test?
Putting her foot down and using her arms for balance.
Those are the ones that you scored her for? Or
I'm sorry.
I'm sorry. Let me rephrase. What are the standardized clues, that the scoreable clues for the one-legged?
Putting your foot down on the pavement, Using your arms for balance. Counting is not a push.
Okay, and then the other one would be hopping.
Oh, yes.
Okay, so when you're scoring the putting the foot down, it doesn't matter how many times they do it, just like put the foot down. I don't know that that's relevant to this one. But. For the using the arms to balance, at what point do you count that? How far do her arms have to come off from her, out from her side?
Approximately 4 to 6 inches.
There's a green tab on that manual there. Yeah. Review what's tabbed on that portion. Six or more inches. Okay. We're going to watch this in a minute here. I actually have a ruler or protractor here that's conveniently 6 inches. I'll let you. You want to take the protractor?
No.
I forgot to give you all the other stuff, so it's just a visual aid. It's a 6 inch protractor. So I guess we're gonna watch and see if we could fit this protractor under her arm during this video.
So then what I'm gonna have you do, when I tell you to,
Do you mind if I move into like a more?
Yeah, no, over here. Let's go. No, you're good. No, you're good. Okay. So when I do, you're gonna split up either one that you choose to on, okay? You're gonna take the ground, you're gonna put your toe and throw over the ground. You're gonna put 1,000, 2,000, 3,000, okay? Does that make sense? Yep. All right, give me just 1 second. All right, and then again, hands at your side, just like this. Yep, perfect. All right, when I tell you to begin, I want you to begin, okay? 1, 2, 3, begin. Not loud. Keep going. 11,000, 13,000, 14,000, sorry. Keep going. 15,000, 16,000, 17,000, 18,000, 19,000, 21,000. Okay, you can stop. Thank you.
No, you on the search warrant affidavit, for the one-legged standing score, Jessica used her arms for balance, right? And she put her foot down. That's fairly obvious. That happened. We can't contest that. And then you also scored stop counting or miscount. Again, you just said a couple minutes ago that's not actually a clue for the one-legged stand.
Correct.
Okay. If it's not a clue, why did you put it in under the one-legged stand?
That it is what I observed is an indication. Well, it might not be a physical clue based on action, reaction, being able to count correctly.
All right. So for the one-legged stand, she's would have scored only one proper clue. Is that accurate?
If you're counting not counting the arms, yes.
Okay. And for the one-legged stand, you need 2 or more clues to, according to the manual, have a good chance to be at or above a 0.08. Would you agree with that? If it'd still be the yellow tab on the small yellow one. If you'd like to review that. Correct. So again, seems like an obvious question. If there's only one clue that would indicate a BAC under 0.08. Then we're going to move on to the walk and turn. We already covered. Now, during the instructions for the walk and turn, let's go forward a little bit. You gave her instructions on how to do the turn once she got to the end of the 9 steps.
A series of small steps.
Yep. Initially, though, you said you take a series of small turns and then correct yourself after she asked for clarification. You remember that? We'll play it. No big deal. Oh.
Your right foot, put it in front of your left foot. Heel to toe. Go ahead and do that right now.
Okay, right foot in front of left foot.
Heel to toe.
All right. This is my right hand. I have dyslexia.
Yeah. That reminds me. I made a note earlier. When you were talking about the instructions, you turned your chair and you said, "Oh, I have to demonstrate it so I get the things right, which foot goes in front of the other foot," right? Yeah, when on direct.
Yes.
Okay, so why is that not a problem, but her dyslexia is a problem?
I don't see why her dyslexia has relevance to this. She mentioned it, but
Well, earlier you said it was weird that she couldn't tell her left from her right.
dyslexia is reading, from my understanding.
Okay. All right. But
Knowing your left hand is the right hand.
But she did say, "I have dyslexia," and did so this is my left, this is my right routine.
Yes.
Okay. All right, so we're gonna watch and see. We got off track. Oh, the turn.
And then, no. Just, yep. Heel to toe like this. Face side. Stay like that until I tell you to stop. Until I tell you to begin, okay? All right, so what I'm gonna have you do is I'm gonna have you take a series of 9 steps, heel to toe, and it's gonna look something like this, okay? 1, 2, 3, 4, so on until you get to 9, okay? When you get to your 9th step, you're gonna take a series of small turns. And you're gonna begin again. 1, 2, 3, and so on, okay?
Okay, I'm sorry.
Do you have any questions?
Yeah, I want 9 steps and then I do like a small circle and tiny
You have to take a series of small steps and then you walk back another 9 steps. Okay, so again, it's gonna be heel.
Okay, so she was actually paying attention to your instructions and caught on to the fact that if she takes a series of small turns, she's going to go in a circle.
Yes.
Okay. And then you corrected your instructions and said series of small steps. Then she conducted the test. All right. Now we're going to go back into the search warrant affidavit for the clues on the walk and turn. Earlier, when you testified with Mr. Smith, I don't believe you gave him the clue of couldn't keep balance while listening to instructions. Yes, that's in your search warrant affidavit. Did you not see any of that on the video today? Did she have trouble keeping balance based on the video that you reviewed today prior to instructions? Okay. And articulate for me when you feel she lost balance.
So she started before she was supposed to, and at that time she was swinging for the balance. And she lost her balance, and then I pulled it away until I pulled it again.
So we can pinpoint that.
This, feet together, okay? Take your right foot, put it in front of your left foot. Heel to toe. Go ahead and do that right now.
Okay, right foot in front of left foot.
Heel to toe.
Sorry, it's my right hand. I have dyslexia.
All right, and then, no, just, yep.
That's what you're talking about? Right, oh,
Heel to toe like this. Hands at your sides. Stay like that until I tell you to stop. Until I tell you to begin, okay? All right, so what I'm going to do is I'm going to have you take
that time?
She puts her hands back in her pockets and we're having to demonstrate. It appears to me as though she was like.
a series of 9 steps, heel to toe, and it's going to look something like this, okay? 1, 2, 3, 4, so on until you get to 9, okay? When you get to your 9th step, you're going to take a series of small turns, and you're going to begin again. 1, 2, 3, and so on, okay?
Okay, I'm sorry.
Do you have any questions?
Yeah, I want.
Well, did we see it yet?
No, I mean, Jared does not look like that, no.
Okay, then the second one you scored was starts too soon. Based on the manual, you only score that clue after you instruct her not to start until told to do so. Would that be accurate? That's the blue tab, session 8, page 44. So although she did start before after you gave her the feed instruction, but after you gave her the instruction not to start, she waited. So the third and fourth one, I don't think there's any dispute that she did use her arms to balance and lost balance there for a second. Could that ankle injury that she alluded to had anything to do with that? Well, when you initially approached her, she said her ankle hurt a little bit. Do you remember that?
The beginning of our.
Correct. Yep.
Yes, but I also had her checked out. I know it's just to make sure she was okay.
Okay.
And they didn't tell me anything about her ankle or any injury that they saw.
Fair enough. And then last, you scored that she would miscount. Now that's not technically a clue, is it? That'd be page 44, yeah, the blue.
Incorrect number of steps before this clue is if it takes more or fewer than 9 steps to do it.
Okay, so it appears that she takes 9.
First step, she stepped on her foot twice and then put her foot down, but counted it as 2 steps.
Let's watch it again. And
Tell me
when.
Okay, so again, it's going to be heel to toe like this. 1, 2, 3, 4. Go on, and then when you get to your 9th step, you're going to take a series of small steps just like this, and you're going to do again. 1, 2, 3, and so on. So you get to 9 steps, okay? All right, do you want to do my instructions? Okay, all right. Go ahead. You're going to have to count out loud.
1, 2, 3.
So explain to me what you mean by she counted.
For the one right before it, when she first started, she didn't count out loud. And
Okay.
she put her foot down on the top of her toe. And then put it down again on top of the toe, then on the line and counted it as 2.
Okay, but she only took 9 steps on the line. Right?
I don't recall. I have to look at our report.
Oh, we're looking at the, yeah, I'll back it up. I'm just confused because it looks like she starts to take the step. She just doesn't count the first step and then she catches up counting, but maybe I'm looking at it wrong.
You're gonna have to count out loud. 1, 2, 3, 4, 5, 7, 8, 9, and then a series of smaller steps like this. Now I go backwards.
Yep. Yeah.
9,
Correct.
1, 2, 3, 4, 5, 6, 7, 8, 9.
Okay.
So I think it's just a matter of interpretation, so we'll move on to that. Then, so also in this search warrant affidavit, you have number 7 down here. The box is filled in. I'm assuming that means you checked it. That is the section in regard to hemophilia and diabetes. Did you read that section, Ms. Bai? Two. Let me get there without Zoom shut down. Snuff.
I can probably work with getting it off, yeah.
Are you okay if I do this?
Yeah, go for it.
All right, Ms. Jessica, I have to read this to you verbatim, okay? I am a police officer. You are under arrest for the offense of operating a vehicle while visibly impaired due to the consumption of alcoholic liquor, a controlled substance, other intoxicating substance, or a combination. I am requesting that you take a chemical test to check for alcohol and/or controlled substances or other intoxicating substances in your body. If you are asked to take or took a preliminary breath test before you arrest, you must still take the test after you. If you refuse to take this chemical test, it will not be given without a court order, or you may seek to obtain such a court order. Your refusal to take this test shall result in the suspension of your operator's or chauffeur's license, vehicle designation, or operating privilege, and the addition of 6 points to your driving record. After taking a chemical test, you have the right to demand that a person of your own choosing administer a breath or urine test. You will be given a reasonable opportunity for such a test. You are responsible for obtaining a chemical analysis of a test sample taken after the selection. The results of both chemical tests shall be admissible in a judicial proceeding and will be considered with other admissible evidence to determine your innocence or guilt. Will you take a blood test?
I honestly don't know. Like, this feels like something I cannot answer a yes or no question at this point because I don't have any information about how those tests are accurate, take the accuracy, or like the situation I'm being put into.
Your question is straightforward.
It doesn't feel straightforward to me. Well, because it's a yes or no, but it's a yes or no depending on details and factors that I don't know.
Okay, so the next step is your own 2 hours. I will quickly up something that you have going on. Okay? Thank you.
Again, did you read those, right, Stuart? Okay. All right, and lastly, in the affidavit, you put in there, Jessica refused the PVT. What was her rationale for refusing that again? If you remember.
Basically, the other.
And why do you take people to get blood tests, even if you have a good PVT read?
To confirm,
Is a PVT admissible at trial? And to your knowledge, why is it not admissible at trial?
I don't know.
Fair enough. Sharing my screen and double check, make sure I don't forget anything. Is not looking someone in the eyes a typical sign of intoxication? And earlier, after Mr. Smith asked you essentially, why did you arrest Miss Bai? You responded to him and said that part of it was because there was a crash with an injury. Why did you add the injury part in there?
The injury portion, I guess it just to speak back, this is just a regular crash incident.
That. I think I've covered everything. Thank you.
Redirect?
No redirect.
I just have one question, I think, one of these. Can you indicated, I think, when you were speaking to the other officer, that he was, I think, asking if the speech of the defendant was slurred. And you said she was speaking like a typical girl who had a drink. I don't know what that means.
I, as a girl who drinks, sometimes my voice can go a little bit higher, and I slur based on my own, reviewing of, sometimes I'll take videos, or I have friends who are females who talk a certain way too.
Okay, so her you thought maybe her pitch was higher, her voice pitch, and then and you did detect slurred speech?
Yes.
Okay. Any redirect based on my question?
No.
Thank you, sorry, you're excused.
Would you like the exhibit that was admitted?
Yes, please.
May I approach? Get her off the chair.
I don't know who some of these attorneys are that are in there. I see Daryl. Give me just a moment off the record on this matter.
Okay.
Can you mute him, please? I see Sazan Barda.
Good afternoon, Your Honor. How are you?
I'm okay. How are you?
I'm doing great. Just got an email from Addie. I think she's going to put us in a breakout room with the defendant for a pretrial statement when they appear.
I was just going to ask you which matter were you here for?
Oh, sorry. Portfolio Recovery Associates versus Michelle Lopez.
Okay, perfect. We're in the middle of an exam and a motion hearing for a criminal matter. So if you are able to resolve the matter, then you can just message Addie back in the chat feature.
Sounds great, Your Honor. Do you know if our motion for summary disposition is also scheduled today, or is it just a pretrial?
Both are scheduled today, but they will not be able, I won't be able to take care of it until I deal with the criminal preliminary examination and motion that I'm currently in the middle of right now. But
Sounds
both
great,
were
Your Honor.
scheduled.
Hopefully I can resolve it.
Thank you.
Thank you.
And then I know Mr. Darlene is here on the MTS matter, but no one's appeared yet on his.
76611B.
For the defendant, at least.
just.
And Counsel, you settled the matter?
I did, Your Honor. I'm just gonna email a conditional dismissal to the defendant for signature, and hopefully you'll get that back to you in the next 14 days.
Very good. You're all set for today. Thank you.
Thank you. Have a great day.
Same to you. Did we see anybody here for, let's see. Norris?
He's here.
Oh, okay. Got it.
If the court could let
Yes.
Ms. Lopez know that she doesn't need to stay as well, that would be great.
Thank you. She's
Thank you.
back. Ms. Lopez, you're free to go.
Could I potentially request to talk with Ivan in a breakout room just prior to meeting?
Okay, we're back on the record. Any additional witnesses?
No, the defense does not have any additional issues. We will rest, or the people.
People rest.
The people rest.
Thank you. Okay, let's see. And are you calling any witnesses today?
No, Your Honor, we have no witnesses.
Proceed to argument.
Well, Your Honor, before we proceed to argument, I will move to admit the results of the laboratory report that was taken as a result of the blood draw. In this case, the laboratory results indicated that the defendant's blood alcohol content was a 0.094 grams of alcohol per 100 milliliters of blood.
You don't need to, but I'll take judicial notice. It's actually in the file.
Okay.
Because it was part of the affidavit of probable cause.
So, thank you, Your Honor. I believe the people have met their probable cause burden on both charges here to take count 2 first, Your Honor. I believe you heard testimony today that the defendant, at the very least, on film admitted that she was distracted when she was driving, whether or not that distracted driving was indicator of she was doing something in the car, or a combination of her blood alcohol plus doing something in the car. The defendant did go through a stop sign and cause an accident, which caused a serious injury to the witness that you heard today. So I believe, based on the testimony heard today, we've met our burden for count 2. As to count 1, the OWI, and to take defense counsel's motion and respond to this motion, I'd like to first start off with the probable cause for the search warrant to draw the blood. Your Honor, I believe you again heard testimony that the defendant admitted to the officer while she was on the scene that she drank a Long Island iced tea within 2 hours of having been involved in a 3-car serious accident. You heard testimony that the defendant was slurring her speech. You seen on the video that the defendant had a hard time keeping her balance. She had a hard time telling her left from her right. She had a hard time walking in the straight line. She had a hard time remembering exactly what her daughter's name was, or how it was supposed to be given to police officers. So based off of the testimony and the statements that you heard today from the defendant, I believe that there was probable cause to get for the magistrate to sign the warrant to search our blood. Now, in the actual affidavit, again, there was a little bit of an issue about when Officer Hyatt smelled, or how she smelled, or when she smelled alcohol on the defendant during this accident. She said that she had a stopped up nose, but when she moved around downwind from the defendant and she got closer to the defendant, she was able to smell alcohol. And there's also an issue with point number 7 here, which indicates that the officer was supposed to read that to her verbatim. I believe the exclusionary rule has a good faith exception. You heard Officer Hyatt ask the defendant about any medical conditions that she had, not specifically related to the search warrant, but related to her being able to complete the field sobriety test. During that, the defendant spouted off a bunch of different medical conditions that she had. None of those medical conditions were a condition that was outlined in number 7. So to the extent that number 7 of the search warrant affidavit was not read verbatim to the defendant, I believe a good faith exception would overrule that it wasn't read verbatim to the defendant. And again, based off of everything, even without the standard field sobriety test, I believe that there was probable cause for a magistrate to sign this warrant to search her blood. Now, when it comes to the standard field sobriety test, the law only requires that Officer Hyatt complete these standard field sobriety tests in substantial compliance with the National Safety Transportation Administration. I believe, based off of the testimony that you heard And the video that you saw, that Officer Hyatt did complete the standard field sobriety test in substantial compliance. And she asked, does she have any medical conditions? The defendant said no. If there was an issue with the defendant's ankle at the time, she very well could have said at that time, hey, I can't do it. I was just in an accident. My ankle's hurting. I don't think I can perform a one-leg stand. I don't believe I can do the walk and turn. She never said that. She had an opportunity to say that. Again, whether or not that was because she was stressed or because she was under the influence, that's a matter of that should be, that's a point which she could have clarified, I believe, had she been sober. But she was asked to do each test. She performed poorly on each test. And I believe based off of what you heard from Officer Hyatt and the extent to which she explained the test, that she did substantially comply with the NHTSA standards. So I would ask that you rule that those the tests are admissible at any trial against the defendant. So again, with those two arguments, I would say that the Officer Hyatt had a good faith belief that the defendant was intoxicated, and I believe she substantially complied with the NHTSA standards. And based off her training experience, the defendant declined the PBT, and she rightfully asked for a search warrant of the blood. She got the blood back, and that blood indicated that she was at a 0.09. So I believe the people have met their burden on count one. Thank you, Your Honor.
Thank you, Your Honor. So just going to make it clear, I think there's two decisions, obviously, that the court needs to make. One, that the court needs to decide whether there's probable cause in the search warrant affidavit after the misstatements are taken out, according to People v. Mullen and DeBrune were cited in my brief. It's theoretically possible that the court could find there's probable cause for an arrest. We're not saying that there is, we're arguing there isn't, but it's theoretically possible. You could say, okay, Officer Hyatt had enough probable cause to arrest Ms. Bai, and there can also not be enough evidence in the search warrant affidavit because the magistrate is looking at the four corners of the documents. They can only go based on what's on that search warrant affidavit. Nothing else. They weren't there. So the people in their response, they ask you to deny the motion specifically for factual disputes. Well, obviously they're factual disputes because we're saying that there were misstatements. The test was not administered and scored correctly. And then there's also the misstatement, lie, however you want to classify it.
When you say misstatements, you're specifically talking about when she said she smelled intoxicants, or are we talking about how she scored?
Both, Your Honor. I would call those both misstatements. The alcohol, I don't know what other reason she would say I don't have a sense of smell for her partner. I akin that to an excited utterance. Why would she tell her partner away from everybody else, I don't have a sense of smell, but she's talking like a valley girl, so I think she's drunk, essentially. That directly contradicts what she put in the affidavit. Is it possible she smelled alcohol later on? I guess it is possible, but how do you go from no sense of smell to smelling?
Well, she said she was stuffed up, so if she smelled it later, was she supposed to then announce it? Hey, I smell it now.
Not necessarily.
So what was she supposed to do if she smelled it later? Not included in the affidavit because she previously said she couldn't smell it?
No, I wouldn't expect her to do that.
Yeah, I mean, I think it's possible. Obviously, if you are congested, your ability to smell as easily could be, restricted. And so she, I think, did a great job of flushing that out on the stand. Well, it was going downwind, and when I was talking to her about the pre-instructions, I could smell it then. I agree, it's a little questionable, but it's possible.
Not arguing with the court. It's your job to determine credibility and what you believe. So there's a question mark there is all I'm saying. The misstatement specifically that I'm referring to in the case law is misscoring the field sobriety test. I think People v. Mullen is very clear. If you don't score it right, it's a false statement. It's got to be wiped from the affidavit. And again, they also ask you to deny for a misunderstanding of the law. In the people's response, there was no contradiction of the law that I cited. So I'm just going to assume they agree with me. They're conflating the search warrant with probable cause to arrest. They are two different things. And they also rely heavily on the PVT refusal. It's our argument that she has an absolute right to refuse a PVT. She correctly opined they can be inaccurate. We don't use them in trial for that very reason. I think it doesn't matter what I think, but it's a civil infraction, so the court's not going to look at it, but it's akin to the right to remain silent when you're being interviewed. You have no obligation to give the state any evidence. You don't have to cooperate with them. The testimony did show us a lot today. It's our contention that the video showed that she was not slurring her speech, and the issue over her child's name, that is something difficult to explain. There's a non-binary name change going on there. She was just in an accident. She admitted, and the officer testified that she was really shaken up while she was talking to the police.
I think she admitted it to the officer. I noted that myself.
Correct.
She admitted, I'm extremely shaken up right now.
Right. And as Your Honor noted, people are nervous when they're talking to the police. They're nervous when they're in a courtroom. It's natural. We already talked about the sense of smell. The officer herself admitted that if those field sobriety tests were scored properly, they're indications of under a 0.08. So had they been scored properly, the inference is different. The walk-in turn, I think objectively, she failed that. I'm not going to argue with the court on that. Objectively, the clues say she failed it. There could have been a reason for it. It could have been her ankle. It could have been the uneven ground that she had previously moved from and went back onto because there was a white line there. Again, that's
roadways were wet. It was inclement weather. It could have been a number of things, but those all create questions.
Correct. And then specifically, the field sobriety tests are scientific in nature. It's outlined in the manual. The officer read it. You have, and that's why it's governed by MRE 702. If you don't administer them the same way every time, you don't count them the same way every time, they're unreliable. You can't just pick and choose other stuff and say, well, that's a clue, but it's not a clue. It's expert testimony. If you don't follow the formula, it doesn't work. Individually, all these issues may not be an issue. If it was just one statement here and it doesn't comport with the evidence, okay, we can overlook it. But cumulatively, it creates a false sense of intoxication for that magistrate that's reviewing the affidavit. So based on that testimony, we're asking you to strike all of the miscounted clues. I can go through all those if the court wants. I don't necessarily know that I want to waste your time because it's all in writing in front of you. Again, it's up to your decision on the smell. She had an explanation for that, so we're gonna move on.
Even without the standardized field sobriety, you don't believe that there was sufficient probable cause based off her admission that just before then she was drinking Long Island iced tea.
No, Your Honor, it's not illegal to drink and then drive. It's illegal to be over 0.08.
Right, but we're looking for a probable cause, right? To see whether or not we, can get a search. And we have an accident. The officer asks you what happened. You don't really know. You were just driving and all of a sudden you don't know what happened. And I do agree that there was moments where I felt like, although she probably could be shaken up because she had an accident, that she seemed to have lost some control. It was the moment on the video where she was specifically questioned about what happened, and she just goes into, I assume I missed, traffic, or, I was talking to my child. I don't really know. I'm extremely shaken up. She puts her hands to her head. It was like at that moment she's trying to grasp control, but you don't believe those were sufficient in conjunction with now you're telling the officer while all this is happening that you didn't have the ability to properly divide your attention because you're driving and you're talking and all of a sudden you miss traffic. And then you were just drinking a Long Island iced tea, which if you drink, that's a lot of alcohol in it, within less than 2 hours prior to. And then I don't know if I have the same concerns about the name thing because it sounds like there was a recent change, maybe, I'm not sure. So I don't know if I buy that was a concern. But that then taken into conjunction with let's give Officer Hyatt credibility in that she did in fact smell alcohol when she was giving some pre-instructions.
Well, Your Honor, I think after you take what I've argued out of that, you're at the De Bruin analysis, and we're arguing that there's not enough probable cause there and again, we're making two different arguments here.
Right.
Probable cause to arrest is one thing. And Your Honor, you're discussing everything for the arrest.
No, I'm talking about probable cause for search. She's for a search warrant, because if I get a search warrant, the same search warrant this magistrate signs could have went to me if I was on call that day. If I get a search warrant that there was an accident, that the officer smelled alcohol, and that the officer, that the person admitted to drinking, if I scratch all the other clues that we were miscalculated and we leave the limited that you give credit to, you don't think that's sufficient for a search warrant?
No.
Okay, that's your argument. You can continue.
It is. And again, lastly, I just want to address the count 2, the reckless driving. Reckless, it's a willful and wanton action. They have to take on a known risk or ignore a known risk. Missing a stop sign, it can happen to anybody. She did say she was distracted by her child, who was by all accounts having a meltdown, and she was trying to deal with it. And then lastly, the good faith exception, based on the question marks that we have in the search warrant affidavit. Generally speaking, you can't rely on a good faith argument if the officer drafting the affidavit is relying on the search warrant. You can't claim good faith if they made the mistakes that led to that, but that is all. Thank you, Your Honor.
Thank you. Any further argument from the people?
None.
Today is the date set for preliminary examination and a motion to suppress the evidence. The burden at the time of preliminary examination is squarely upon the prosecutor. They have to establish that they have sufficient probable cause that felonies were committed and sufficient probable cause to charge you as the person who committed the felony. So this is not a trial. You don't have to prove each element beyond a reasonable doubt. It's a very low burden of proof. It's just more than mere suspicion. The court is the only determiner of credibility at this portion of the prosecution stage. And I'll also weigh the likelihood of the people's success if this matter were to proceed to trial. And I essentially will obviously do that because I have a motion to suppress here. I think it's important to take the motion to suppress first. There was a motion to suppress the evidence and dismiss the case based on misstatements or perceived misstatements made by the swearing officer, that was Officer Haven Hyatt. And your attorney has requested that I strike any miscounted clues. And then if that being making the affidavit insufficient, then thereby I would have to dismiss the case because there would not have been sufficient evidence presented at the time of the request for a search warrant to proceed with the search warrant. Again, I have a search warrant here where the officer reports to an incident of a 3-car accident on or about November 9th, 2025 at the area of MLK and Olds Avenue. That's in the city of Lansing, Ingham County. That would make venue appropriate in this court. The officers, Officer Hyatt, that is seems to be the one in charge of the investigation. Maybe she was the first officer there. She makes contact with, at least what I saw today, with a witness and or party to the accident, Stephanie Randall. And she was involved in the accident. She stated she was driving. She glanced down momentarily at her speedometer and looked up only to be colliding or making a collision with the defendant. She said she suffered a severe tibia, I believe, injury. She's been unable to do much since the time of that injury, she says. And she was tearful, even as she was giving her testimony. It sounds like she currently is operating or moving around with a cane or with some other limitations. We then heard testimony from Officer Haven Hyatt. She's been an officer with the Lansing Police Department for about 2.5 years. She testified to being A-RIDE certified and that she reported again on that date and time to the incident. And she noted 3 vehicles having been involved and that there was some injuries. When the body cam of Officer Hyatt was displayed, the officer, I think, asked everyone that she communicated with if they had any injuries. And specifically as it relates to the defendant in this matter, Jessica Bai, she did note or make some indication indicia of her ankle, but nothing to the effect of, I'm having some severe ankle pain, I can't walk, that sort of thing. And she was evaluated by paramedics, just like everyone else. And so as the investigation continued, again, as I indicated while I was questioning both of you all during your arguments, there was questions specifically about, can you tell me what happened? It was at that portion of the video. I don't know that I would, by viewing the video, again, I'm not getting the vantage point of the officer because I'm viewing it through a video who's being played through your computer now to my screen. I don't know that her speech appeared slurred to me, but I wasn't the person there. But I do believe that portions of her interaction with the officer struck me as some concern that I would have wanted to investigate it further too. And that was specifically when questioned about what happened. It seems like she was a little bit more collected in the beginning while she was standing off to the side with her daughter. But then when it came time to really discuss more detail of what could have happened, I don't know if it maybe struck her as, whoa, what did I do or what happened? And that may have just been an overwhelming of emotions, which could happen. Or it could be that when you're under the influence, you're less able to control yourself in your responses. In that instance, the response that I recall was the defendant stating that she just assumed she missed traffic. She was talking or having a communication with her child, and that may have distracted her. She began crying a little hysterically. She appeared to be trying to gather herself or collect herself while she's speaking. But she states, I'm incredibly shooken up. She admitted to, when the officer asked her, have you been drinking? She admitted to drinking a Long Island iced tea within the 2 hours prior to that, just not too far from the location where the incident took place. I would say it was probably about within a 2-mile radius of where the accident took place. And that the officer is then seen, Officer Hyde is then seen having a conversation off-site about some concerns, requesting it, quite frankly, at this point, if anyone has a PBT, and it's then where the officer that she's speaking to asks her if she could smell alcohol. She discloses there, well, my sense of smell is off. He asked, was her speech slurred? And she says, well, she's talking like a typical girl who had a drink. That to me is not clear, which is why I specifically asked, well, what does that mean? In her testimony today, she says she used herself as an example. She's a girl. For the record, I'm a girl too. She's a girl, and when she drinks, her voice, she says, get a little more high pitched, and I guess based off that and the nature in which the responses were coming from the subject at the time, it caused her to believe that she was under the influence. She states then on the record that she believed that the defendant's speech was slurred. Again, I didn't get that assessment watching the video, but I recognize that things don't always translate the same. The same way I recognize, even as you were playing the video while she was doing the walk-in turds, different vantage point. This officer may have been able to see in person and or from a dash cam, if that was available, the defendant walking on her toes twice. I can admit that I probably saw it once, or what appeared to be her maybe stepping on a little bit on her toes. I didn't see it twice, but again, the vantage point is not the same. And there's a multitude of data that goes into how we skew and weigh evidence when it comes to body cam because of that point. There's testimony about the defendant sharing that she has a scoliosis, that she has asthma, she has astigmatism, and I believe there was a concern about possible dyslexia in giving or receiving the instructions. I agree that the officer did not properly administer the SFSTs at every point. Do I believe that there was substantial compliance? I personally don't believe that there was substantial compliance. And that's, if I'm being frank, it's been an ongoing issue because of the lack of training. And this is a younger officer. She's only been here 2.5 years. I think that she did what she thought was substantial. But I don't know that her compliance rises to the level of substantial compliance. If I were to even remove, based off your motion, the information that is misscored, I think we still have probable cause. because I do think that the moment when she's directly questioned about what happened, the breakdown there, the officer's statement, albeit there is a question of fact there. Did she in fact smell? Because she's already stated on body cam that she couldn't smell, but then she later says she smells it later. That's possible. She could have smelled it later. She presented completely credibly inside the court. And so she could have smelled alcohol later. It's in the affidavit. I think that it's reasonable to believe that she could have smelled it when she had a later communication. If she got closer to her, then maybe she got before, or if the wind was blowing in a different direction. I think that the communication that she had with her, even while she was administering this SFSTs, also would cause someone to believe something's going on. And again, it could have been that she was nervous, but also could have been that she was under the influence. And so that coupled in conjunction with an admission that I just drank and an accident that we have, a 3-car accident where you can't tell me whether or not you blew the sign or you don't know what happened, you were just talking and next thing you know, you missed traffic. Something there rises to the level of concerning, and taken into totality with the other concerns that we have, I think that there was sufficient probable cause for a search warrant, regardless of pulling out miscounted clues. So with that, your motion to suppress is denied. The court also believes that there is sufficient probable cause based on the evidence presented today to bind over count 1 and count 2 to the circuit court for further prosecution. The bind over date is going to be May 20th. That's the date the circuit court receives the file from the district court. It is not a date that you, Ms. Bai, need to appear in court. Your next court date will be a pre-trial in the circuit court, and your attorney will be made aware of that date, okay?
Thank you.
You'll stay in communication and contact with your attorney. Ma'am, do you have any questions at this time?
I'm not allowed to say, am I allowed to say anything?
Well, you probably don't want to say anything that could be used against you, but this is your opportunity if you have any questions for me specifically.
I don't have any questions.
Okay, yeah, your attorney is here to ensure that you're not saying anything that could be used against you. And again, I told you this is a low standard, just more than mere suspicion, okay? Any additional matters for the record?
From the people, Your Honor.
No, Your Honor.
A bond will continue, you're all set.
Sorry. Okay.
I don't think the, this is your exhibit back, sir. I don't think that we have anybody here for the 1:30, unless I missed it. No Mercedes Williams?
Yeah, nobody for that one.
Nobody for Cox either?
Sorry.
No.
Can I get an email with from the clerk's office with the pretrial and circuit court?
Circuit court will contact you after they receive the file.
Perfect, thank you.
No problem. Okay, so then we must dismiss that one, I suppose. And then, is Norris and Darling back?
Yes, Your Honor.
You all resolve your matter?
Potentially, but I am a little unfamiliar with 54A district court. So is it okay if we run a stipulated order by you to see if it complies with, I guess, the procedures of the court and okay with you?
Let me call the case. This is SMTS Real Estate Group versus Gabriel Norris in 26-00685. Can I have your appearance officially for the record, please?
Ivan Darling, appearing on behalf of SMTS Real Estate Group.
Okay, and then I see Mr. Norris. Please state your name for the record, please.
Yes, Gabriel Norris representing myself as pro se.
Okay, this was a motion to stop an eviction. The parties met privately, and counsel, you have a stipulated resolution?
Yes, this is what we agreed upon. We will set aside the current judgment, withdraw, terminate the current with writ, but we will amend and or submit a new conditional dismissal with different terms. And the terms are payment of $3,655, but still allow for the same immediate order of eviction shall be entered pursuant to MCL 600-5744 parentheses 3 upon any further default under the terms of the lease, and then also the same for any possible holdover situation. And that should bring us pretty current and address a lot of our issues and kind of resolve the current matter, at least for now, but still have the conditions that we could reopen, reinstate the case, and then apply for an immediate writ.
Okay, and Mr. Norris, is that accurate as to how you want to proceed? Frozen?
Yes, I mean, I think there might be a couple of things within the dismissal that I might like to talk to Ivan about once I see it, but overall, yeah, we are on pretty much the same page.
Okay, so you're not prepared to put the conditional dismissal on the record at this time? Is that correct, counsel?
That is correct. We're still mulling a few things over. I just kind of wanted to see if more it's in line with this court's policies and way of going about things. And with that being said, also, would I just send in an order to set it aside and then do an order to either withdraw or terminate the current writ, or is that something that the court would handle?
Okay, so, well, how about I do this? I mean, because I was gonna say, if you're still not even sure of what the terms are, because I would have liked to get them on the record today, I think it's beneficial to just, I could set this motion out to another date so that you can have time to mold over those additional terms. And then we place the new conditional dismissal on the record. And you can, I'm sorry?
Well, can I present one more possible condition? I know one of the concerns from Mr. Norris. I was gonna say, Mr. Norris, would you agree that the condition would be for the holdover? Sorry, I'm kind of put on the spot and I'm trying to think of how to do this. It's something that I just kind of thought of, but it will be the same conditions for a holdover situation, but only limited for non-payment of rent if it's not non-payment of rent to a certain point. Because our concern is that allowing this to keep going, we might have to restart this process over and over again upon further defaults and all of that, and it kind of creates a situation. But we can limit it to
how much time was you got? I don't know what your new conditional dismissal was gonna give him for time to comply. Like, what were you trying to give him?
He's gonna, can we just set it out to a later date? I think that's, since
yeah,
we're
because I was
not,
gonna say this can be reset. You haven't hashed it out, but my other thought process was this could be resolved, in between now and the next matter, and I don't know what all the terms are, but if it's a matter of some money and some other things, maybe you all can get this completely resolved, and then the need to stop an eviction is a moot issue. But I don't know, because I don't know what all the terms are.
Essentially, my initial terms were to present a stipulated agreement to get signed by the landlord, just to accept that they would not act on the writ of eviction and get rid of that, so long as I tendered the full amount that we agree is owed plus May's rent, which is April, May, and then what's owed. And there were just a couple little extra things that we were hashing out, really. So, but that's the main thing. I do have the money to pay and to cure the amount, and I just wanted to get on the record that the stay is there and that the writ wouldn't be executed if they receive payment.
And we're
Yeah.
we're okay with that initial part. Like I said, there's just a few other things. If you want, we can continue talking about it, and we can just possibly, once we get it ironed out, if we get it done quickly, we can submit it to the court for a signing, and that could probably take care of the next hearing if you want. But we can have that next hearing just as on the books for now, tentatively, if that's okay with you.
Okay, let me get.
That's
your
okay with me,
date.
if it's okay with the court.
May 28th at 1:30. May 28th at 1:30.
All right, thank you, Your Honor.
All right, thank you, Your Honor. Is that available by Zoom, or do we need to come in person?
Yeah, we'll appear the same way by Zoom.
All right, thank you, Your Honor. Enjoy your day.
Thank you, you're all set. Be same to you.
Okay.
Mr. Charnock is here for, is DeAndre Carter? He is. Okay. See here. No one appeared from Williams. Let me get this on the line. Let's see. Okay, on the record in matter of case Credit Union versus DeAndre Carter, this is 11-04297 GC, council appearance.
Good afternoon, Your Honor. Scott Chernich on behalf of Case Credit Union.
Okay, and then Mr. Carter, please state your name for the record.
Good afternoon, Your Honor. My name is DeAndre Carter.
Okay, this matter was a reset date for a review. Mr. Carter was supposed to turn over some documents. Mr. Charnock, did you get what you were looking for?
We did not, Your Honor.
Why is that, Mr. Carter?
Your Honor, I've decided to file bankruptcy. I'm awaiting a case assignment number in which I would be addressing that matter in that format.
Okay, when did you file for bankruptcy?
I'm in the process of doing that now, awaiting a case assignment.
Or did you file?
I'm filing today. I am awaiting the case number. It's not, I don't have the case number yet.
What were the documents that you requested, Mr. Charnock?
They're voluminous and were attached to our subpoena, Judge. It covers the gamut of bank accounts, title documents, the normal panoply of documents that I asked for.
Okay, Mr. Carter, are you employing an attorney to file bankruptcy on your behalf?
Can you repeat the first part of that question, Your Honor?
Do you have a bankruptcy attorney?
I will be finalizing that this afternoon. I have consulted several and making a choice.
I'm gonna find you in contempt of court for completely disregarding the court order. This has been going on for way too long, and you had documents that was sought that you refused to turn over, and coming to court after you were told and given another additional 7 days, and you said on my record that you would have them turned over within the next 7 days. For you to come in here and tell me that you're just working through, you're going to finalize, it's almost 3 o'clock. If you don't have a bankruptcy attorney retained today, you're not filing bankruptcy today. These are games that are being played. And they're not okay. It's not okay to waste the court's time. It's not okay to disrespect the process. It's not okay to waste the attorney who's trying to recover the debt on time. This is not acceptable. And you know better than this. Where are the documents that were requested?
I have gathered some of the documents and
Where are they right now? I want to see the documents.
they're electronic. I could submit them. Like I have bank statements and copies
They're
of checks.
electronic? You
Yeah,
have them right now? Because we're here electronically. You have them right now.
yes, I have a copy saved on my desktop computer.
Email them to Mr. Chernick right now.
Okay, the bank statements were digital. I have paper copies of the other creditors that was requested. Would you like me to do a screenshot for that to attach to the email?
However way you can get those to Mr. Chernick today. I'm going to reset this for next week. Do we have a date available next week, a time available next week? So to confirm that he has received and reviewed to make sure he got what he was supposed to be getting. The case doesn't stop because you're telling us that you're going to go ahead and file for a bankruptcy. That's lip service and it's delay tactic. And so you're going to actually have had filed and this was discharged or being reviewed for discharge. And that has not happened. And so you have not, you cannot now circumvent the process on your own volition by not complying with a court order. This is not Mr. Chernick's order, it's a court order. And I'm going to give you to next week to comply. Otherwise, I'm going to issue sanctions for delay tactics and tying up the court's time, and you're not acting in good faith. So you need to turn over the stuff that's requested, and you need to act in good faith, and you have to do it before next week.
May 15th at 1:30.
May 15th at 1:30. That's the final time I'm resetting this.
Understood, Your Honor.
Thank you, Your Honor.
You're all set for today.